Welcome all the participants and good afternoon. We are on the day 2 of the last week of our session. और हमारे साथ जो है मैं मनीष श्रीवास्तव सर का भी वेलकम करना चाहूंगा। सर भी हमारे साथ जुड़ चुके हैं। तो जो प्रोग्रेस है, हेलो, प्रोग्रेस रिपोर्ट हम सबमिट करें, फीडबैक फॉर्म
यस सर।
Yes, sir, we are doing.
सबका है। और जो बाकी हमारे ग्रुप के मेंबर आ गए थे उन सबका प्रेजेंटेशन तैयार हो गया है।
तो मैं सो फाइल भी लगा। यस सर। ये रही
Yes, sir.
फाइल।
ठीक ठीक है, तो मैं ज़्यादा टाइम नहीं लूंगा। आज हमारे मनीष सर जो है इसका सेशन लेंगे और जो हमारा आज का टॉपिक रहेगा वो हैंडलिंग ऑफ कोर्ट केसेस रहेगा। इससे पहले आपने दिखाया कि सर ने एआई के ऊपर और कंडक्ट रूल के बारे में, विजिलेंस और डिसिप्लिनरी केसेस के बारे में हम कैसे करेंगे उस बारे में डिटेल जो है हमारे को सर ने एक्सप्लेन किया। और आप जानते हैं कि भाई आजकल लोग जो है अपने राइट्स के प्रति बहुत ही ज़्यादा जो है वो कॉन्शियस हैं और लिटिगेशन भी बहुत ज़्यादा आ रही है। वैसे तो ये कहा जाता है कि भाई जिस इंस्टीट्यूशन में अगर लिटिगेशन वगैरह ज़्यादा आ रही है तो इट इज़ प्रिज्यूम्ड कि एडमिनिस्ट्रेशन शायद उतने अच्छे से काम नहीं कर पा रहा है या समस्याओं को समझ नहीं पा रहा है। और मेरे ख्याल से ये लास्ट रिसोर्ट ही होता है कि इम्प्लाई व्हेन ही इज पोस्ट टू मूव टू द कोर्ट ऑफ लॉ। नहीं तो कोई भी नहीं चाहता कि हम कोर्ट जाएं, कोर्ट के चक्कर लगाएं। लेकिन इफ, ठीक है, एज ए एम्प्लॉय मान लीजिए वो कोर्ट जाएगा, लेकिन एज ए एम्प्लॉयर और एज एडमिनिस्ट्रेटर आपका क्या रोल होगा और आपको कैसे डिफेंड करना है, तो मेरे ख्याल से एक डिटेल एनालिसिस जो है आज सर करेंगे। तो मैं ज़्यादा टाइम लेते हुए सर से रिक्वेस्ट करूंगा कि सर सेशन को स्टार्ट करें। ओवर टू यू सर, मनीष सर।
थैंक यू जॉर्जी। तो
चलो लेके
आ,
जाना तो दिखता हूँ। जाइए को ले जाओ ना यार, मेरा भी स्टार्ट हो गया सेशन।
मैं शेयर करता हूँ डॉक्यूमेंट। तो पहले हम लोग लास्ट क्लास से थोड़ा सा जो बच गया था उसको फाइनलाइज करेंगे। आज बहुत सारा इन्फॉर्मेशन शेयर करने के लिए है तो थोड़ा सा मैं स्पीड में चलूँगा। अम, अगर आपको कहीं पर कोई क्वेश्चंस हो तो आप ज़रूर उसको पुटअप करिएगा। और अभी जो मैंने पिछली बार विजिलेंस पे सेक्शन लिया था, अगर किसी को अभी क्वेश्चन है उसके बारे में तो वी कैन टेक अप बिफोर वी स्टार्ट दिस। एनी क्लैरिफिकेशंस, क्वेश्चंस, कंसर्न्स अबाउट लास्ट क्लास? कुछ नहीं, आगे बढ़ते हैं। तो हम लोग यहाँ पर आकर के रुक गए थे कि एक्स पार्टी इंक्वायरी, रीजनेबल अपॉर्चुनिटी, नेचुरल जस्टिस, बर्डन ऑफ प्रूफ, प्रीपोंडरेंस ऑफ प्रोबेबिलिटीज। जनरली ये चीज़ें हम डिस्कस कर चुके हैं, बस थोड़ा सा रिविजिट करेंगे ब्रीफली इसके बारे में। सो एक्स पार्टी इंक्वायरी जो होती है, अगर इंक्वायरी ऑफिसर को लगता है कि जो चार्ज ऑफिसर जो है वो पार्टिसिपेट नहीं करना चाह रहा है, डिस्पाइट नंबर ऑफ रिमाइंडर्स, डिस्पाइट नंबर ऑफ नोटिसेस, वो एक्स पार्टी इंक्वायरी कंडक्ट कर सकता है। अ, अगर ये लगता है कि वो चार्ज ऑफिसर को कांटेक्ट ही नहीं कर पा रहा है, वो ऑफिशियल अब्सकॉन्डिंग है, गायब है, तो एक न्यूज़पेपर में नोटिस पब्लिश करना अनिवार्य हो जाता है। अदर मीडिया जो है उसके माध्यम से भी ये इंफॉर्मेशन परसू करना बहुत इंपॉर्टेंट है, बिकॉज रीजनेबल अपॉर्चुनिटी टू द चार्ज ऑफिसर इज वेरी इंपॉर्टेंट। जैसा कि हमने नेक्स्ट पॉइंट में एक्सप्लेन कर रहे हैं कि रीजनेबल अपॉर्चुनिटी जो है वो चार्ज ऑफिसर को डिफेंड करने के लिए बहुत इंपॉर्टेंट है। इसीलिए कोशिश यही रहती है कि एक्स पार्टी इंक्वायरी नहीं होनी चाहिए। एक्स पार्टी इंक्वायरी जो है अवॉइड करने के लिए ऑनलाइन आप इंक्वायरी भी कंडक्ट कर सकते हैं। यूजिंग ऑफ टेक्नोलॉजी इज वेरी मच परमिसिबल। देन वी टॉक अबाउट नेचुरल जस्टिस। नेचुरल जस्टिस की आपकी ऑलरेडी क्लास हो चुकी है, सो आई एम नॉट गोइंग टू गो इनटू यू नो डीप इनटू इट। बट नेचुरल जस्टिस का मतलब ये है कि प्रिजम्पटिव आइडियाज आपके पास नहीं होने चाहिए विद रिगार्ड टू समवन हु इज बीन चार्ज्ड। अब हम लोग बर्डन ऑफ प्रूफ की बात करते हैं। बर्डन ऑफ प्रूफ इसके अंदर क्या होता है कि बर्डन ऑफ प्रूफ इक्वली वैलिड है बोथ ऑन द चार्ज ऑफिसर एंड ऑन द प्रेजेंटिंग ऑफिसर। प्रेजेंटिंग ऑफिसर को ये प्रूफ करना है कि जो बर्डन ऑफ प्रूफ है, मतलब जो चार्ज किया गया है वो ट्रू है। जो डिफेंडेंट है, जो चार्ज ऑफिसर है, उसको ये प्रूफ करना है कि जो मेरे पे चार्जेस लगाए हैं वो गलत है। द प्रीपॉन्डरेंस ऑफ प्रोबेबिलिटी का मतलब ये हुआ कि अनलाइक अदर कोर्सेज केसेस जो कोर्ट में होता है उसके अंदर ये होता है कि यू आर इनोसेंट अनटिल प्रूव्ड गिल्टी। यहां पर होता है यू आर गिल्टी अनलेस यू प्रूव 100% दैट यू आर इनोसेंट, राइट? So this is what preponderance of probability is and this is what the burden of proof is. Proof presenting officer को सिर्फ इतना करना है कि भाई ये doubtful है integrity. Charged officer has to prove that जो integrity है वो 100% clear है, clean है, ईमानदार है, कोई दिक्कत नहीं है उसको. Any questions for now?
No, sir.
Everything is good. Cool. उसके बाद अम, जब ये इंक्वायरी ऑफिसर जो है उसका रिपोर्ट जब चला जाता है डिसिप्लिनरी अथॉरिटी के पास, तो डिसिप्लिनरी अथॉरिटी वो कंसिडर करता है द नेचर ऑफ द चार्ज, फैक्ट्स एंड सर्कमस्टांसेस ऑफ द केस, एविडेंस ऑन रिकॉर्ड, brief of presenting officer, submissions of the charged officer with regard to the findings of inquiry officer, और एक पेनल्टी वो इम्पोज करता है. अब जो पेनल्टी इम्पोज किया जाता है इट शुड बी कमेंसुरेट विद द ग्रेविटी ऑफ द मिसकंडक्ट. मतलब जो मिसकंडक्ट हुआ है उसके साथ कमेंसुरेट होना चाहिए. मतलब डिसप्रोपोर्शनेट नहीं होना चाहिए. इट शुड बी प्रोपोर्शनल. And then after that, a speaking order imposing the penalty must be issued. A speaking order matlab it contains all the information from starting to end, and it has all the information. स्पीकिंग ऑर्डर का बेसिकली मतलब ये होता है कि अगर एक ऑर्डर आपके पास है तो आपको ऑर्डर पढ़ते हुए किसी और किताब को, किसी और रेफरेंस को, किसी और डॉक्यूमेंट का आपको हेल्प नहीं लेना पड़े ये समझने के लिए कि ऑर्डर क्या कह रहा है. अब ये कह रहा है कि जो डीओपीटी का एक ओएम है 2007, ये कहता है कि इफ देयर इज अ सीरियस केस which involves offenses such as bribery, corruption, etc., it should be launched for prosecution as a matter of course. तो उसको आपको स्टार्ट कर ही देना है, राइट. व्हाट इट मीन्स इज दैट अगर ब्राइबरी आपको नजर आता है तो आपको स्ट्रेट अवे इंक्वायरी इनिशिएट कर देनी है, राइट. और जो whether the respondent is guilty of such conduct as would be merit of his removal from service or a lesser punishment as the case may be. जो डिसिप्लिनरी अथॉरिटी है उसको डिस्क्रिशन है कि भाई किस लेवल पे हम इसको इनिशिएट कर सकते हैं, राइट. अब ये अगर हो गया तो जो क्रिमिनल प्रोसीडिंग्स है वो इनिशिएट अगेंस्ट द गवर्नमेंट सर्वेंट होनी चाहिए या नहीं होनी चाहिए. सो दैट अगेन इज अ डिस्क्रिशन विद द गवर्नमेंट. हाउएवर विद द एडमिनिस्ट्रेटिव लॉ वो ऑटोमेटिक नहीं होता है कि क्रिमिनल प्रोसीडिंग्स शुड बी इनिशिएटेड और शुड नॉट बी इनिशिएटेड. सो व्हाट हैपेंस इज अगर बहुत ही ग्रेव चार्ज है, राइट, फाइनेंशियल एम्बेजलमेंट, फाइनेंशियल मिसअप्रोप्रिएशन, so it is desirable that before the departmental inquiry a formal FIR is lodged and criminal proceedings are initiated against the person. अगर ऐसा लगता है कि ये बहुत ही गलत एक्शन हुआ है, क्योंकि डिसिप्लिनरी प्रोसीडिंग्स इनिशिएट करने में आप एट द मोस्ट डिसमिसल कर सकते हैं. क्रिमिनल प्रोसीडिंग्स के सजाएं अलग होती हैं. सो इट शुड ऑलवेज बी टेकन इनटू कंसिडरेशन कि कौन सा ज़्यादा इंपॉर्टेंट है. और इलीगल ग्रेटिफिकेशन और ब्राइबरी और इस तरह की केसेस के अंदर यू नीड टू टेक अ कॉल कि कौन सा कोर्स ऑफ एक्शन ज़रूरी है. बाय चांस क्रिमिनल प्रोसीडिंग्स ऑलरेडी स्टार्ट हो गई हैं, so you should try not to start your disciplinary proceedings till जो क्रिमिनल केस खत्म हो गया है. बिकॉज पेंडिंग क्रिमिनल केस, आई मीन यू कैन डू दैट, बट in general you should try to stop initiating a disciplinary proceeding pending a criminal case against any government servant. डीओपीटी ने सुप्रीम कोर्ट जजमेंट के आधार पे ये इट हैज बीन क्लैरिफाइड दैट in if there is a criminal trial it is not mandatory for you to initiate disciplinary proceedings, right. जो भी डिसिप्लिनरी अथॉरिटी है वो डिसिप्लिनरी प्रोसीडिंग्स लेना है या नहीं लेना है डिपेंडिंग अपॉन द फैक्ट्स एंड द सर्कमस्टांसेस एंड द गाइडलाइंस गिवन बाय द कोर्ट. दे हैव टू अबाइड बाय दैट इंफॉर्मेशन. अब हम आ जाते हैं जो पेंशन रूल की हम लोग बात कर रहे थे. ये इसका जो रूल 8 है वो कहता है कि जिसको भी पेंशन मिल रही है, इट इज सब्जेक्ट टू अ फ्यूचर गुड कंडक्ट। दैट मीन्स while you were a government servant, you did nothing which could be called unbecoming of a government servant. The same holds true even when you get retired. So आपका कंडक्ट जो है वो आइडियल होना चाहिए, गुड होना चाहिए, बेस्ड ऑन द कंडक्ट रूल्स होना चाहिए। एज फार एज एम्प्लॉयमेंट, नॉन एम्प्लॉयमेंट ऑफ रिलेटिव्स एंड फैमिली मेंबर्स आर कंसर्न, दैट इज अ डिफरेंट थिंग। इट्स जस्ट अबाउट योर कंडक्ट, राइट? और रूल 9 कहता है द इवेंट ऑफ ट्रांजैक्शन विद इन 4 years बिफोर द इंस्टीट्यूशन डिपार्टमेंट प्रोसीडिंग्स विद अट्रैक्ट एक्शन अंडर दिस पेंशन रूल्स। व्हाट इट मीन्स इज कि अगर आपके अगेंस्ट कोई डिसिप्लिनरी प्रोसीडिंग्स लाई जा रही हैं और आप रिटायर होने के विद इन 4 years हैं, तो आपको सीसीएस सीसीए रूल्स के अंतर्गत नहीं बल्कि पेंशन रूल के अंतर्गत आपको डिसिप्लिनरी प्रोसीडिंग्स इनिशिएट करती हैं। और अगर आप पेंशन रूल्स के तहत डिसिप्लिनरी प्रोसीडिंग्स इनिशिएट करते हैं तो सैंक्शन ऑफ द प्रेसिडेंट इज नेसेसरी इन टर्म्स ऑफ द गवर्नमेंट ऑफ इंडिया एम्प्लॉइज। व्हेन इट कम्स टू योर public sector employees, it is open for approval. Head of the department approve करेगा, क्या करेगा, ये internal guidelines पे depend करता है। इसके लिए प्रेसिडेंट ऑफ इंडिया की, एज फार एज आई बिलीव, ये जरूरत नहीं है। सो इससे हमारा जो डिसिप्लिनरी प्रोसीडिंग्स और कंडक्ट रूल्स है वो खत्म हो गया है। इस डॉक्यूमेंट के अंदर मैंने ये एक फ्लो चार्ट है मेजर पेनल्टी का, कैसे होल्ड करते हैं। ये मैंने लिया है मैनुअल ऑफ डिसिप्लिनरी प्रोसीडिंग्स डिपार्टमेंट ऑफ पर्सनल ट्रेनिंग से। इस प्रेजेंटेशन की कॉपी झाजी के पास ऑलरेडी है, नहीं है तो मैं इसको दोबारा भेज दूंगा। इट इज जनरली वेरी हैंडी। मेजर पेनल्टी का है इसके अंदर, क्या क्या रिक्वायरमेंट्स आपके पास होने चाहिए, बायस क्या क्या होता है, और उसके बाद माइनर पेनल्टी के क्या प्रोसीडिंग्स है। ये भी एक फ्लो चार्ट इसके अंदर है। सो आई विल हैंड इट ओवर टू झाजी। अगर या उनके पास पहले वाला है तो इट्स गुड, नहीं तो मैं ये वाला दोबारा दे दूंगा। सो फार इज देयर एनी क्वेश्चन टिल नाउ? एवरीथिंग गुड, क्रिस्टल क्लियर? वेरी
यस
गुड,
सर।
बहुत बढ़िया। अब हम लोग चलते हैं हैंडलिंग ऑफ लिटिगेशन इन गवर्नमेंट।
सर एक छोटी सी क्वेरी है सर।
हाँ हाँ, गो अहेड प्लीज।
सर मान लीजिए द अथॉरिटीज हैज इनिशिएटेड स्टेप्स फॉर, इनफैक्ट अथॉरिटी ने रिजॉल्व किया कि भी हम मेजर पेनल्टी इम्पोज करेंगे,
ठीक है।
ठीक है। बट द थिंग इज दैट कि जब उसे आगे जो अप्रोप्रिएट अथॉरिटी के पास ले जाया गया, वहां पर अथॉरिटी ने बोला कि मेजर पेनल्टी नहीं लगेगी। जो भी जिसके अगेंस्ट ये प्रोसीडिंग्स चलने का वो था, उसने जो अपना रिप्लाई दिया, उसको देखते हुए अथॉरिटी ने बोला कि माइनर पेनल्टी के लिए आप इसे टेकअप कर लीजिए, ठीक है।
तो जब ये हुआ तो वो अथॉरिटी कौन थी जिसने ये डिसाइड किया कि हम मेजर पेनल्टी करेंगे, और वो अथॉरिटी कौन थी जिसने बाद में कहा कि मेजर पेनल्टी नहीं करेंगे, माइनर पेनल्टी करेंगे? व्हाट इज
सर
द डिफरेंस बिटवीन द टू
बोर्ड
अथॉरिटीज?
board first instance firstly the charge sheet was issued by
हम्म।
the secretary to board of management.
हम्म।
Then the reply to charge sheet was placed before the board of management.
ओके।
Seeing the reply, the board decided, let us withdraw the charge sheet and initiate proceeding for minor penalty.
ये बोर्ड ने डिसाइड किया,
जी।
और बोर्ड के पास ये
Accord-
अथॉरिटी है?
जी सर, जी जी।
ओके।
Accordingly, board withdrew that charge sheet. Later, the disciplinary authority issued a memorandum for minor penalty on the same charges.
ओके।
Once the charge sheet is withdrawn,
ओके।
can minor proceedings be initiated on these charges which have already been withdrawn?
जनरली ऐसा होना नहीं चाहिए। चार्जशीट इज जनरली इशूड व्हेन यू ऑलरेडी डिसाइड दैट मेजर पेनल्टी प्रोसीडिंग्स हैव बीन इनिशिएटेड। और
जी
जब
जी।
आप चार्जशीट विड्रॉ कर लेते हैं, दैट मींस दैट यू डोंट स्टैंड बाय योर चार्जेस, राइट?
Yes.
तो In general, what it means is that you are withdrawing the charges, right?
Yes, sir.
However, the decision to hold a minor penalty for those charges is discretionary. Uh, मैं ये नहीं कहूंगा कि it is totally wrong, but it sets a wrong precedence.
Yes, sir. Once the
लेकिन
charge
अगर
sheet is
इंक्वायरी
withdrawn, once the charge sheet is withdrawn, that says that the charges leveled against the employee have been withdrawn.
एग्जैक्टली
Then, yes, sir.
दैट्स
तो
व्हाट इट मीन्स.
जी जी जी, ठीक है सर, थैंक यू थैंक यू।
लेकिन अगर आप ये जब चार्जेस विड्रॉ कर रहे हैं उसके अंदर आप मेंशन करते हैं कि द चार्जेस वर ड्राफ्टेड एंड इट वाज सर्विस्ड विद एन इंटेंशन टू होल्ड अ मेजर पेनल्टी, हाउएवर ऑन रिव्यू इट वाज फाइंड दैट the disciplinary authority has decided to initiate a minor penalty proceedings, a fresh charge sheet will be issued under rule so and so. ये हो सकता है, हालांकि ऐसा करना नहीं चाहिए ये, क्योंकि आपने अगर ऐसा कर दिया और वो कोर्ट में जाता है तो मेलिफाइड इंटेंशंस जो है वो साबित हो जाते हैं बहुत इजीली.
बिल्कुल सर, इट विल बी अ मेलिफाइड इंटेंशन। जो चार्जेस विड्रॉ हो चुका है उसको हम दोबारा से टेकअप नहीं कर सकते। इट विल बी डबल जेopardy।
नहीं, डबल जेपार्डी ये नहीं हुआ. डबल जेपार्डी तब होगा जब उसको पनिशमेंट मिल गई उसके लिए.
ओके,
और
ठीक है
डबल जेपार्डी का मतलब होता है एक ही क्राइम के लिए एक से ज्यादा बार आपको पनिशमेंट देना. दैट इज डबल जेपार्डी.
ठीक है सर, थैंक यू सर।
By merely issuing a charge sheet, it's not a double jeopardy. हालांकि like it has to be mentioned why you are withdrawing, and you should be able to defend that decision. If you are able to defend that decision, because ऐसा decision आप लेते हैं तो court में it cannot stand. It can never stand that why you initially wanted to have a major penalty and then you resigned it and then you wanted to have a minor penalty.
Actually the employee had replied a number of biased attitude of the authorities.
Okay.
That is why board withdrew that major penalty decision.
फिर तो माइनर भी नहीं होता है ना, अगर बायस्ड है तो माइनर किस लिए.
जी 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 सर,
ये भी आई वॉश है.
बिल्कुल सर।
इफ यू विड्रॉ इट मतलब ऐसा होना चाहिए. वो आई वॉश करके और उसके बाद फिर कोर्ट में जाकर के सरकारी पैसा खर्च करके कोर्ट में हार जाना, ये तो बेइज्जती कराने वाली बात है.
बिल्कुल सर, थैंक यू सर।
या यू वेलकम. तो अब हम लोग ये थोड़ा सा मैं डिटेल में लेना चाह रहा हूँ, हैंडलिंग लिटिगेशन गवर्नमेंट. इसके अंदर हम लोग दो चीजें कवर करेंगे. पहले तो हम लोग लिटिगेशन को समझने के लिए एक ओवर आर्किंग जो आर्किटेक्चर हमारा जो कोर्ट सिस्टम है उसको समझेंगे. और उसके बाद हम लोग एक स्पेसिफिसिटी में चले जाएंगे जहां पर हम लोग सिर्फ सेंट्रल एडमिनिस्ट्रेशन ट्राइब्यूनल के बारे में बात करेंगे. और जब हम सेंट्रल एडमिनिस्ट्रेशन ट्राइब्यूनल के बारे में बात करते हैं तो जो प्रोसेस और प्रोसीडिंग्स जो उसकी होती है मोर और लेस सिमिलर टू स्टेट एडमिनिस्ट्रेटिव ट्राइब्यूनल होता है, राइट. सो that's why I'm talking about litigation in the government. When it is litigation in the government, it is not only because of the service matters. There can be litigations in different aspects and different respects. I can put in perspective one example. Like for example, अगर आप कोई एडमिनिस्ट्रेटिव ऑफिसर या असिस्टेंट रजिस्ट्रार जनरल एडमिनिस्ट्रेशन आप कर रहे हैं, आपने कोई टेंडर लीज आउट फ्लोट किया और उस टेंडर के अंदर कोई फ्लॉ हुआ एंड समवन गोज टू अ कोर्ट ऑफ लॉ, that is also handling of litigation. This is not service matters. However, as part of your administrative rules, you will have to handle those kind of litigations as well. That is why, for this particular aspect, I'm focusing on uh, the litigations overarching expanse as opposed to just the central administration tribunal or state administration tribunal, right? सो सबसे इंपॉर्टेंट क्या चीज है, व्हाई डू वी एक्चुअली नीड इफेक्टिव लिटिगेशन मैनेजमेंट? कौन बोलेगा? किसी भी ऑर्गेनाइजेशन में लिटिगेशन मैनेजमेंट इफेक्टिव क्यों होना चाहिए? एनीवन? नो वन? एनीवन हैज हैंडल्ड कोर्ट केसेस? किसी ने कोर्ट केसेस हैंडल किए हैं?
Yes, sir. Yes, sir.
ओके, cool. तो आपको क्या क्या प्रॉब्लम्स सामने आई जब आप कोर्ट केसेस हैंडल कर रहे थे?
Normally, sir, when we impanel the university councils,
Mm-hmm.
hello, uh,
Yeah, go ahead.
are you audible, sir?
Yes, yes, yes.
So the first thing is there is no, any established litigation management policy kind of for the university, and case to case basis. Initially, the councils were engaged by the university. Okay. So first thing we face is that how to impanel the effective lawyers to defend in various forums in various courts. Like say we are from Uttarakhand. So when we were impaneling the advocates from the this High Court of Uttarakhand, so we asked the Bar Council to provide some nominations, but even then it was not that effective impanelment. So it is very discretionary kind of practice. So whenever any authority of university, decides that this lawyer should be impaneled or that lawyer should be impaneled. So every year, some cases are being handled by the earlier impaneled advocate, and then again, the university authorities like registrar or vice chancellor decides that no, we don't need to, pursue the cases with that earlier impaneled advocate, but a new lawyer should be impaneled. So it creates complications in handling the cases. So that was the beginner's issue. Like so,
Yeah, that's true. Dr. Dhyani, thank you for sharing your experiences.
yes,
So
sir.
it is very important for us to understand that litigations will happen. And the fact that we have to depend on councils to actually defend the government or an institution is very important. And uh, it's so anyone who goes to a court of law is actually looking for a redressal of a grievance, right? They can be right, they can be wrong. And sometimes there will be person who are just the sole intention of that litigation is just to delay the process. However, an effective management means, number one, that your institution is ready for any such litigation, right? Number two, your institution recognizes that the mechanism of grievance redressal through litigation can be addressed within your institution, right? And it will ensure that if there is an understanding or litigation management structure exists, it will ensure that the responses will be speedy, it will be economical, and there will be a speedy resolution of disputes. So ये the understanding है institution में होना बहुत जरूरी है. That's why we are discussing this with you that prima facie you should have an idea that if अगर आग लगी तो क्या करना है, right? So basically that's what we are trying to do over here. So whenever there are grievances, right? What are the channels of redressal in the government apart from the internal structures which exist to make sure that these grievances are redressed? There are two main avenues, दो मुख्य channels होते हैं जिसके थ्रू grievances जो हैं उसको redress किया जा सकता है beyond the institution, outside the institution. One is the central administrative tribunals or state administrative tribunals. Uh, it is designed specifically to resolve issues related to service conditions, pay transfers, other administrative matters very fast. Um, सो बेसिकली जो एडमिनिस्ट्रेटिव ट्राइब्यूनल्स है ये इसलिए हैं क्योंकि जो बर्डन ऑन रेगुलर कोर्ट्स है वो बहुत ज़्यादा है और इसका रीज़न ये है कि दे वांटेड टू प्रोवाइड अ फोरम विच इज़ एन एक्सपर्ट एंड डेडिकेटेड टू सर्विस रिलेटेड मैटर्स एंड डिस्प्यूट्स. जो कैट है इट इज़ अ कोर्ट. Its procedures are judicial and not quasi-judicial, as we had discussed about the administrative proceedings. Um, they formalize fairness over formal procedural rigidity. So what it says is that in government there's a formal rigid structure of hierarchy, right? So CAT actually uh, takes care that any formal rigidity in the government which was involved in a biased execution of disciplinary proceedings can be taken care of, right? Next is CAT's flexibility helps in delivering decisions more quickly. Um, and because of the fact that CAT is specialized in this particular aspect, it dispenses off the cases very fast. The second avenue is the courts of law. Any matter which is beyond the service matters, which is beyond the service conditions, space transfers, or other administrative matters, uh, or any matter which is beyond the purview or jurisdiction of CAT, goes to a court of law. Uh, the jurisdiction of a court or a CAT will always depend on the subject matter, the geographical factors, which means the location, the status of the person, active or retired of the employee, and so forth. Like they can be any number of parameters which can be used to decide the jurisdiction of the court. But these are the main things which need to be taken care of.
Excuse
So
me, sir.
yeah, go ahead.
Yeah, just a little query. I never find any case of the university or autonomous bodies which is being handled by the CAT. So, is there any possibility that the autonomous body employees or staff can explore the CAT for their grievances?
So what you're saying is that if there is a disciplinary proceeding and if there's a penalty imposed,
Yeah,
the grievance redressal mechanism utilized by employees of the universities, they don't go to CAT or SAT, they go straight away to
yeah,
court.
yeah, yeah.
Okay, that I'll have to see because what is the mandate of court? I think that I don't have pretty much fair idea in terms of universities
Okay.
whether they should go to CAT or not, but as far as my understanding is that service matters should be looked into CAT. So I'll you know what? I'll send an email across to Jhaji regarding this. But this is a good thing for you that if someone goes directly to court and if we find that for service matter they are supposed to go to CAT, you can actually object this at the very first instance that the court of appeal which has been chosen is wrong and the matter should be transferred to CAT or SAT. But I will have to confirm
Yeah,
whether.
that's the reason, sir. Actually,
Hmm,
I am looking after the legal matters of the university from 2016 onwards.
hmm.
So for this period, several times court remarks that, basically all the employees or staff who are having any grievance towards the service conditions or any other service matters, they approach to High Court directly. Okay. So sometimes the court remarks that, has the petitioner, explored the available remedies or the forums before approaching to the honorable court. So, but ultimately, it is the practice being followed by the autonomous bodies as far as I'm, aware of. So most of the time, for the slightest, grievance, every person is approaching to the High Court directly. And now it is a common practice that High Court are, entertaining the writ petitions on first submission itself. So it is very difficult to, reduce the burden of court proceedings on the universities or the educational institutions. Like say at a given point of time, more than, every month around 50 to 100 court cases are being filed against the institutions. So nowadays, these are piling up. So, is there any way of handling these kind of things that we can put in our counter affidavits to the High Court that okay, that particular person has not availed the possible remedies before approaching to the court, like CAT or any other grievance redressal mechanism.
I think you should do
So,
that. You should do that because I'm just going through the CAT. Nowhere it says that it is only restricted to the government servants.
okay, so autonomous bodies are not covered under that, I guess.
No, it doesn't say it's not covered.
Okay. But nobody is going to that. Nobody is availing. I never
So
heard,
if you look at this,
sir.
jurisdiction of CAT, All India Service, Union Civil Servants, employees of PSUs, various departments and ministries. So probably, right? Because it doesn't exclusively say that the universities or those kind of institutions get covered in CAT. Neither do they say that they are excluded,
Okay.
right?
Right, sir.
Uh, it's important then. Like, I mean, if the university's employees are not covered in CAT, then it becomes very different, and the things that we are discussing. So thank you for bringing that out to me right now. But again, you we need to confirm that.
Actually, even I am not aware of any, such instances. Maybe not in our university, but maybe DU is there. So I'm not aware of that as well, that whether DU employees, or there are cases which has been referred to the CAT from the DU or somewhere else.
You
So
cannot refer the cat like a case to CAT. Generally, what happens is the grievance is the person who's aggrieved goes to CAT, right?
yeah, exactly, sir. But
And
there
High
are,
Court is the next stage. It's a court of appeal after CAT.
yeah, yeah,
So, but I'll get back to you on that,
sir.
right?
Thank you.
So, when we are dealing with CAT cases, just understand that that's exactly how you're supposed to deal that cases in a high court as well, right? So probably, but still, I'll be going through the CAT, and maybe next time, just try, saying that it's an administrative or service matter. The aggrieved person has not yet, uh, uh, you know, uh, used all the redresses available, and probably they should go to a central administrative tribunal, or but I'll get back to you on that, whether central universities employees or state university employees go to a high court or they can go to a CAT, right? Okay. So, why administrative tribunals have been there is because the court cases, they are increasing in number. In many cases at district level. Um, Again, one thing, when someone is going with a writ petition to a high court, they're straight away just using a writ petition, right? They are not filing any grievance in terms of what they've faced at the university, at a like a sessions court or a district court. They don't do that, right?
No, 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 sir. Not at all. Not at all.
Okay, they straight away file a writ
Yeah.
in the high court, and you're not able to counter that writ.
Yeah,
That's what your
it's,
experience
it's
shows.
difficult. It's quite difficult to,
So have you ever tried to say that filing a writ at this point in time is too early for them?
Yeah, and moreover, sir, when Honorable High Court decides any matter, okay, then we are left with only one choice to challenge it. Maybe if it is a single bench, then to DB in High Court itself. But
Mm-hmm.
as far as teachers of the faculty members of the university are concerned, they are heard by the double bench only in High Courts. And after that, only remedy available is with the apex court, that is Honorable Supreme Court. So you don't have enough chances or opportunities to defend the interests of the university in that case.
That's an interesting insight, Dr. Dani, and thank you for bringing that up, because that makes me feel that I need to go dig deep into, like, whether uh, I mean university employees or teachers not going to an administrative tribunal tantamounts to their not exhausting the remedies available
Yeah,
under this. So, because, like, if people have been doing that and without exhausting the remedies under this administrative tribunal, so there is a possibility that they may not actually be eligible to go to an administrative tribunal, because administrative tribunal doesn't accept their cases, which I don't think should be the thing. Um,
definitely, sir.
but next time, what you can try to do is that filing a writ is too early in the case, because they need to exhaust the remedies available under the administrative tribunal before they can actually file a writ
Yeah,
in the High Court. try
Otherwise,
doing that and let's see
yeah.
what happens. And have a
Otherwise,
council
too
which can
difficult.
actually defend that.
Yeah. Otherwise, it's too difficult to establish that they haven't exhausted the available remedies, because the remedies in that case is portrays as the vice chancellor of the university or the executive council of the university. They say, the petitioner normally says that, I have moved a representation before the authority, that is the vice chancellor of the university, or say if it has been referred to the executive council, in that case that remedy is executive council itself. And afterwards, if there is any delay in the decision, suppose say if it has been rejected by the authorities, that is another case. One set of cases are where the representation moved by any petitioner has been already rejected by the university authorities. But the other case is if they have, simply delayed that decision process, even then they are moving towards the directly to the honorable court.
Anybody else in this group who's handling court cases?
No, sir.
No
No,
one.
sir.
Okay, cool. So no, this is an interesting remark because like when I see that jurisdiction of Central Administrative Tribunal, it mentions employees of public sector undertakings. Um, but I'll have to dig deep what exactly that means. Does it cover the universities, autonomous bodies or not? Because if it does, then you have a valid reason to actually write at the onset target that they have not exhausted the remedies to quash their writ petitions in the court. Uh, right? And if they are not eligible, they are not covered by the administrative tribunals, then there definitely is a need for the universities to move to administrative tribunals and request them to include the central universities and autonomous organizations in administrative tribunals, because that's the whole purpose of setting up administrative tribunals, whether it is central or whether it's state, to make sure that the service matters and these kind of matters don't delay the proceedings of high court, and they don't overburden this. So let me get back to you on this. But thank you for that valid point. Um, so over here, while I'm explaining how to handle the CAT cases, you can actually use those aspects to handle the cases responding to the writ petitions in the high courts as well, right? So thank you, Dr. Dhani. Let's move forward. Um, so okay, the most important aspect is that many cases at the district level arise from service matters, and I mean, you can always challenge any writ petition in the court of law that at least like they should not file a writ directly in a high court. If it is a service matter, if they're not going to an administrative tribunal, they should at least start at the district level, because I mean, they can always say that we are filing a writ, so that's why we are not going to a district level. You, as someone representing your institution, can always argue that filing a writ is not a desirable move in this particular aspect. They can always challenge the decisions of the university or the institution, if not in CAT, then at least at the district level in the sessions court as a civil matter. So, effective administration and timely resolution of genuine employee grievances, it's also very important. Uh, and judicial independence is actually means that the government cannot interfere in the court proceedings, and the principles of natural justice are more vehemently implemented in a court of law rather than in the administrative proceedings. So we all know this is how the hierarchy of the courts are. We have tribunals, which are specialized in forums like tax, land, consumer disputes, administrative matters. So there are tribunals. Then there are lok adalats, village courts, and then there are district level courts established in every district, which include civil and criminal courts. Decisions are subject to review by the High Court. High courts are the highest judicial bodies at the state level. They generally hear appeals from the lower courts and they also adjudicate on writs. Apex Court, it handles original and appellate jurisdiction. The original jurisdiction generally are, again, writ petitions. Original are matters which are between two states or states and the government. And there can be petitions which are original petitions in the Supreme Court, which are related to the interpretation of legislations, statutes, or constitution. So, the civil courts, what are the functions and jurisdictions? The purpose is to resolve civil wrongs, right? So, civil wrong means it can be a property dispute, it can be a breach of contract, it can be divorce, it can be anything which is not related to the criminal proceedings. This is governed by civil procedure law, and I think this has not been changed as opposed to the criminal proceedings and the evidentiary proceedings, which is been changed last year into our own different laws with different names. So every suit in a civil court starts with the lowest court and proceeds based on the value of the subject matter, right? So in civil courts, plaintiff is the person who files the suit, who's the complainant. Defendant is the person against whom the complaint is filed, and plaint is a short form of the word complaint. Now, if someone files a civil suit against you, you can always counter file a complaint against them. So what happens is, when there is a court case, there will be a person, a plaintiff, who files a complaint against you. You become a defendant. However, the defendant can countercharge the plaintiff. This happens only in civil courts, not in criminal courts, right? So in that case, there will be two aspects discussed in a civil court. The first aspect will be the plaintiff with a complaint for the defendant, and then a defendant's counter complaint against the plaintiff, right? The terminologies can be a little bit different, varying on which courts you go, but this is how it generally operates in civil matters, right? So when you come to a district court for civil matters, uh, so a district court is presided by district judges, which is the highest civil court in the district. There will be an additional judge and an additional sub-judge in the courts. They will handle cases subject to matters which are exceeding 1 lakh rupees. And then there will be a Munsif court, which deals with small value cases. Uh, and based on anything which has not been covered by these courts or any new evidentiary aspects which may have been discovered, decisions of these courts can be appealed in a high court. Now let's yeah, go ahead.
Sir, a small observation, sir, if you
Please.
permit me.
Yeah,
So
sure.
actually, as far as the civil courts are concerned, sir, district courts and all that, most of the universities, especially central universities and most of the state universities as well in India, they are established by the Act of Parliament or Act of Legislative Assembly. So actually, what is happening? The Act bars the remedy of civil courts. That's why there is only one remedy available with any petitioner, that is High Court.
So in what you're saying is in all the acts, district level adjudication of civil matters is barred.
Yes, civil courts are barred, besides only High Court.
No, of course, like it's a high court. When you go to high court, you're actually filing a writ. It's not a like a civil matter in a district court.
Yes, sir.
So if they are barring this, then
Sir.
definitely like if they're barring this level of management of courts, then definitely I think this also means that the administrative tribunals can also be not approached. That's what I believe then.
There is a little bit difference, sir. Actually, acts are barring the civil courts, district level courts, but as far as CAT is concerned, sir, I think the jurisdiction defined by the CAT that excludes the autonomous bodies. PSUs are included, but autonomous bodies are, to my best understanding, actually, I'm
No,
not sure,
I believe when you say that, because of the fact that you're dealing with it, I truly, believe you. I'm not saying I don't believe you.
sir.
Yeah, I truly believe what you're saying. So here's my question, because this is something, because I've been the handling litigation and everything. It's more of a government thing that I generally, talk about.
Sir,
Again, a learning experience for me, and a question to you is
sir,
that if there is a problem, so when you say an act of parliament or an act of legislature establishes a university, right?
sir,
So, if, for example, there is a matter of breach of trust between the university and a vendor, where does the vendor go?
sir. So they are approaching to consumer courts.
So that's a tribunal, right?
Yeah, yeah. Even
And
land disputes, if it is a matter like land disputes, sir, so they are being
Mhm.
heard by the district courts. But as far as service matters are concerned, because
so
most
you
of
have
the,
you are saying that specific to service matters, the
sir,
district level civil courts are barred.
yes, sir,
Oh, cool.
yes, sir.
If that is the case, then definitely like that then they don't have any option but to go to a high court, right?
Yeah, but
Then
what
it's a
I
fact.
was
Then
concerned
it's
about, sir, I was just
Mhm.
exploring the possibilities of tribunals only. Actually, district courts, I know when the act of the university itself bars that, so there is no other remedy, besides approaching to the High Court. But as far as tribunals are concerned, sir, state tribunals are there for the state universities, say, and central tribunals are, say, having the jurisdiction over the central universities. In that case, if it is possible to explore that possibility, I'm not sure whether it is totally barred, but as far as the mandate of CAT is, I was looking at your presentation itself, sir. So when they say that they are having the jurisdiction over PSUs, but they are not definitely saying that autonomous bodies are included under that or not. So that is the point of exploration.
No, very true, very true. That's why I said that let me take a look and get back to you. But because like if that is the case, then of course handling of writ petitions is a completely different ball game than handling court cases in CAT.
Definitely, sir.
However, like the basic premises when we talk about handling of court cases in terms of what should be done, how it should be done, the management, all of that is nearly similar. There can be certain nuances which can be different, but when it comes to how do you tackle the information, how do you submit the information, what should be the structure of the response, what should be the guidelines that are being followed by someone who's responsible for court cases in an organization, that kind of remains similar, right? So no, a wonderful observation, and thank you for sharing that because as per my knowledge, I was not aware that the employees of central and the state universities are not going to administrative tribunals, and perhaps this is what we believe that the central and the state tribunals they don't cover service matters of universities. So that's an interesting thing to know. But we'll still go over the process because when I say the process, just assume that we are trying to address how to answer the writ petitions when it comes to the procedural aspect. We'll go over that because that's how the presentation is. It's talking about CAT, but uh, based on my experience and how I've handled the court cases in the court, the basic methods of looking for loopholes, looking for different things, they remain the same. Like how you can target someone's responses, what you're supposed to do when you receive a court case, right? So those procedural aspects will remain the same. So instead of when I say CAT, you read it High Court,
Yeah, sure,
right?
sir.
Cool. Um, and then criminal courts, they try and punish persons accused of criminal offenses. The cases are filed by the government. That means there has to be a police report, which is then, taken to a court. As per as I said, like the criminal proceedings, it has been replaced by Bharatiya Nagarik Suraksha Samhita. and the section 6 of Bharatiya Nagarik Suraksha Samhita, it shows like what is the hierarchy of the key courts in the criminal proceedings. So it's Court of Sessions, which is the session court, judicial magistrate, which is first class, which is metropolitan magistrates, judicial magistrates of the second class, executive magistrates. So if you look at the structure of the civil courts, you will find it a little bit comparable in terms of how the structure is. So a district court is a session court, a sub judge is judicial magistrate class 1, Munsif court is judicial magistrate class 2, and then the last one is equivalent to the executive magistrates in terms of criminal courts, right? The importance of criminal courts is that there is a prosecutor, and the prosecutor's duty is to ensure proper charges are levied, and they should secure witness attendances and manage evidences. So, what is the binding value of the judicial precedents? The Supreme Court decisions, it binds all courts across India. High Court decisions, it binds all lower courts within the same jurisdiction, may be persuasive in other states, but they may not be binding in other states. When it comes to lower court decisions, it must follow higher courts rulings within their state jurisdiction. The purpose is to ensure consistency and uniformity in legal rulings. Why this differentiation between different states is because different states may have different legislations based on which certain decisions can be valid and certain decisions may tantamount to invalidity of the high courts or lower courts jurisdiction within that state's purview. We will now talk about like the court proceedings. What are the type of proceedings? So there are writ petitions, which are for enforcement of fundamental rights. Writ petitions are always filed in Supreme Court and High Court, not filed below that. Original applications, they are filed before administrative tribunals for service-related matters, and they are filed in civil courts in case of civil litigation. There can be other proceedings which can have in different tribunals. It can happen in Lokayukt and human rights commissions. So when it comes to writ proceedings and procedures, the writ types, they have been defined in Article 226 and Article 32. So they are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Is everyone aware of what these writs mean or not? Anyone would like to explain any of this?
No idea, sir.
Okay. Yeah, go ahead. Oh, no idea. Okay, cool. So it's very important for you to understand that the writs in the Constitution, it has been provided to actually force the government or anyone to actually uh, do something or to prohibit someone from doing something, right? Habeas corpus means that you have to produce the body. What it means is like, for example, the police, they have arrested someone and that person is not traceable at all, right? So a habeas corpus is filed where the court will direct the police to present the person in the court. And there are already like guidelines that they have to be presented within 24 hours of arrest and all those things. But habeas corpus, is related to that. I'm not going into the literal definition. I'm trying to make you understand what it actually means, right? When it comes to mandamus, it actually mandates an authority to do something, right? Prohibition act prohibits an authority or an agency to do something. Quo warranto is basically a question to the authority that uh, how and why you did that, under what authority you did that. And certiorari is basically restraining from doing something. Prohibition and certiorari, the difference is prohibition prohibits and certiorari does not prohibit, it restrains. Any questions?
No, sir.
Cool. So you basically understand the difference. I just gave you like a top level view of these things. If you dig deep into this, like there are separate chapters on each and every writ when you come to learn about these things. So I just wanted you to understand that these are the types of writs and what generally they mean. In general, why do you want to, file a writ of habeas corpus, or why do you want to, file a writ of mandamus? Why do you want to file a writ of prohibition, right? That's one of the things,
Uh,
right?
yes, sir. A small query, sir. So,
Go ahead.
as far as in the case of universities concerned, so mostly we are dealing with the mandamus and creatory. So, we wish to have more insight on that, those two, because habeas corpus and this prohibition and quo warranto are generally not experienced by us, but these two kind of prohibition and this one, this is mostly dealt by the institutions in service matters, in fact.
So, uh, prohibition basically is to quash kind of a decision, some kind of a directive. So, in your case, writ of prohibition means that you've issued the disciplinary proceedings have been, finished, finalized, and you've issued a decision of the disciplinary proceedings by the disciplinary authority of, let's say, dismissal, right? So prohibition prohibits the implementation of that order.
Is it possible, sir, that certain writ has not been, moved or filed under, any specific, like say for mandamus or prohibition or quo warranto, but while deciding the matter, any court of law, makes it that way when it is finally
I
decided?
I don't think I understand your question. Can you repeat again?
Yeah, sometimes when a petitioner moves any
Mm-hmm.
petition before the
Mm-hmm.
court of law, or
Mm-hmm.
say it is not very clear that either it is a mandamus kind of writ
No, it
petition.
should be mentioned when they file a writ. It should be mentioned what kind of
No,
writ.
and if it is mentioned in that prayer, if
Mhm.
it is mentioned specifically, is it
It has
possible
to be
that?
mentioned. It has to be mentioned. You cannot file a writ without mentioning what kind of
Yes,
writ
sir.
you're filing.
So in the prayer part, I know that in the prayer parts, normally they write that, certain, it has to be, in a mandamus decision or something like that. But is it possible that if a petition is moved under certain categories, say for mandamus,
Mm-hmm.
but while deciding the case, the court, make it like provision? Is it possible?
Makes a provision for what?
Like say, anybody is approaching
Give me
the
an
court.
example. Give me an example so that I can understand what you say.
सर से सपोज से कि एक कोई स्टाफ है और वो ये जाता है कि ये एक ऑफिस ऑर्डर है, ठीक है,
Mm-hmm.
रिगार्डिंग माय
Mm-hmm.
सर्विस मैटर्स, एंड
Mm-hmm.
इट शुड बी दिस रिस्पोंडेंट शुड बी प्रोहिबिटेड टू डू दैट, द
Okay,
इम्प्लीकेशन ऑफ दैट. तो
got it.
वो ऐसा ना होके कोर्ट ऑफ लॉ से मेंडामस की तरह से देख के डिसाइड कर दे. इज इट पॉसिबल?
So what happens is when you file a writ in a way that I want a prohibition of this circular, right? What it means is that I don't want this to be implemented against me. That's what the
सर,
writ is, right?
सर,
Court will not say कि आपने जो ये writ of prohibition file किया है, you should file it in mandamus. Court will simply say ये prohibition में नहीं है, we don't accept it.
राइट सर.
कोर्ट इज नॉट अ सजेस्टिंग या इंक्वायरी ऑफिस नहीं है.
सर,
एंड यू एज अ पर्सन हु इज रिप्रेजेंटिंग दिस कैन ऑलवेज आर्ग्यू दिस कि अगर कोर्ट ने प्रोहिबिशन की जगह उसको कहा यार प्रोहिबिशन नहीं मैंडेमस होना चाहिए, यू कैन से दिस इज नॉट द ड्यूटी ऑफ द कोर्ट, इट शुड बी क्वेश्ड एंड दिस शुड बी द वेरी फर्स्ट क्लेम व्हेन यू गो टू द सुप्रीम कोर्ट दैट हाई कोर्ट एक्चुअली डिड दिस व्हिच वाज not a part of what they are supposed to do, right?
okay, thank you, sir.
Am I clear?
Thank you, sir.
Okay, cool. So, any other explanations regarding these writs? कोई question? No? So, मैं एक बार फिर से clear कर देता हूँ. So, habeas corpus basically means that produce the body. What it means is that it actually, ensures a person's right to liberty from unlawful detention, right? Quo warranto जो है, ये आपकी अथॉरिटी को ये मैंडेमस जो है, वो कहता है कि मैंडेट करता है दैट यू शुड परफॉर्म दिस स्टैट्यूटरी ड्यूटी, मैंडेट प्रोवाइड करता है, राइट? व्हाट इट डज इज, लाइक फॉर एग्जांपल, एक क्वासी जुडिशियल ऑर्गेनाइजेशन है आपके यहाँ जो डिसिप्लिनरी प्रोसीडिंग्स कंडक्ट किया है, अगर मैंडेमस का फाइल हुआ है, सो कोर्ट कैन इशू your office to have a committee with certain powers to perform this statutory duty, right? Mandate करता है, right? Similarly, prohibit करता है, right? कोई भी आपका जो ट्राइब्यूनल का एक्शन है या जुरिस्डिक्शन है, अगर आपके फंडामेंटल राइट्स को वायलेट करता है, तो आप वो प्रोहिबिशन का रिट पिटिशन लगा सकते हो। क्वो वारंटो जो है वो कहता है कि भाई आपने किस अथॉरिटी से ये काम किया, व्हाट वाज द अथॉरिटी, सो इट बेसिकली चैलेंजेस द legitimacy of any action, inaction, office order, or an office bearer's action, right? If it actually, challenges your fundamental rights. और lastly, certiorari है। certiorari जो है बेसिकली वो क्या करता है कि हायर कोर्ट को लोअर कोर्ट के केस को रिव्यू करने के लिए या अपने पास बुला लेने के लिए एक वो होता है, ऑप्शन होता है, right? The purpose obviously is to protect individuals from protect individual liberties and ensure judicial review of administrative actions. The filing process is submit a petition stating facts and grounds supported by an affidavit. जो respondent है वो counter affidavit addressing the claims should be filed. So I think we need to take a break here. We are done with 1 hour, and then after 15 minutes we'll be back, right? But before that, any questions on writ proceedings and procedures?
Oh, sir.
Okay, cool. Then we meet after 15 minutes, right?
Hello, sir.
Yeah, hello. You good?
Yeah. Sir, are you willing to take a break for 5 minutes?
हाँ नहीं, मैंने ब्रेक लिया हुआ है।
अच्छा, लिया हुआ है।
I've
Okay,
taken,
the break is going on.
yeah,
Okay, okay.
yeah.
Okay, okay. Okay, sir.
Must be specific and direct and supported by evidence to exactly that particular government. You're not
हाँ जी
supposed
सर।
to club.
नहीं
फारिक जी कुछ कह रहे हैं या फोन पे बात कर रहे हैं? Okay, cool. Okay, it should be very specific. और general जो process जो होता है, that's why it's important for you to have experience in handling of court cases, because what you generally do is you should always have a checklist, and once you have that checklist, you make sure that you check all the things that are required to fulfill a particular requirement, right? Establishing a legal ground. So when you are actually trying to respond to, or if the petitioner is trying to petition, um, the legal stand, the legal grounds, like what legal grounds are violated, right? Or for you, what legal grounds should be, taken in terms of response to the government or the writ petition or whatever. It should always be addressed, right? It like the responses should not be vague. The legal grounds must be mentioned. The relevant sections, the relevant rules, the relevant guidelines, the relevant acts, whatever is the legal standpoint. The legal standpoint are very important and should be mentioned without any fail. It's very important. Apart from that, when you're talking about certain cases, there you have to, like, I mean, of course, you are not supposed to look into. Your counsel will look into it, whether you are filing it or whether you are responding to it. The counsel will always be there. So look for similar cases and the judgments. If it is relevant in the same jurisdiction, it's going to be really very good. If it is not in the same jurisdiction, then it can be relevant, but may not be that important. You can so in order of precedence, you should mostly cite Supreme Court judgments or High Court judgments if it is within from the same jurisdiction, geographical jurisdiction, it is really very good. But if it is not from same geographical jurisdiction or state, if it is from separate state, you still should mention it because it definitely makes sense unless the regulations which are being cited for this court case, they're completely different, right? Um, so do not provide conclusions or comments on any aspect because those things are basically discussions which are held in a court of law by the council. Uh, do not mention anything in terms of interpretations of law because unless it is an administrative guideline that you already know, because generally these are the things which are discussed at the end of court proceedings by the plaintiff counsel and the defense counsel. So do not give any personal interpretations, just cite examples, uh, file rebuttals. Uh, don't say that I believe that this regulation says this, and as per this regulation, this should be the remedy because you're not a legal expert while you're trying to file your responses. Let that be argued by the counsels when the hearings and pleadings are being undertaken in a court of law. Okay, so now we talk about like what are appeals, what are reviews, what are revisions, right? So an appeal basically is a request to a higher court of law to reverse the decision of a lower court after the final judgment. So either it is reversal of the decision of a lower court or some other sort of remedy in terms of changes or a reduction of penalty or whatever. So basically, appeal is something that you go for a remedy to a higher level of judicial authority. A review is different from appeal in terms of it actually asks for a re-examination of a court's decision by the same court, probably as we've already discussed, by a bigger bench, a larger bench in the same court. A revision is something which actually is filed when you need to have correction of errors due to improper reference or jurisdictional issues. It is typically filed in a high court when there is a when something of a lower court uh, final decision or judgment happens, right? Or whether there is correctional or error in the final judgment in a single bench, so it goes to a double bench. An action, what you need to do is when these kind of like appeal, review, or revision petitions are filed, you are supposed to file a prompt filing, and then you need to have a counsel who's there to give you a legal advice on how to handle these kind of things. It is very important. Otherwise, there can be a situation where you misalign your aim in filing these responses from what is need to be done. Okay, monitoring of pending cases and verification of pleadings. So, if you are dealing with regular court cases, it is very important for you to maintain a database, right? If it is in an Excel sheet in a computer, it's always very good. There used to be a system which is called a call book system when the computers were not available, where you used to maintain a register with a callback date of like say 2 weeks, 3 weeks, or 30 days, where you actually look back every single day of a week. You go back to 2 weeks prior cases and all those things, and you have to maintain the dates of hearings, the dates of filing petitions. So nowadays, because of the fact that you have computers, you should maintain a computerized database so that you are able to keep a tab on the dates and the hearings and nothing is missed, right? Um, so whenever like pleadings or anything like that comes to your court, comes to your office, it must be initially verified by the concerned party or an authorized person. And I personally believe that nowadays the courts have online verification portal where you can actually, use the court case number and go to the website and verify whether it's a genuine complaint or not. Maybe sometimes someone is just, taking a printout from a computer and sending to your office as a false something, and like you start jumping on your seat that what should I do based on this complaint, but then you realize it's not a genuine complaint, it's someone falsifying some sort of a pleading and sending it to you just to make sure that you have some sort of a problem or tension, or you know uh, just to create problems for you, right? uh, So initially, when there were verification statements, that it used to be gotten verified by a court of law. Now you can do it online. So initially, you had to send a verification information to a court to actually verify whether this is a genuine thing or not. Uh, and like, I mean, this is not relevant nowadays because verification process is not something which is undertaken now. But as a process, it is always important for you to verify. And then whenever you have documents, you have to make sure that all the documents uh, they are corrected and attested, and pages are clearly numbered so that they can be referenced while they are being discussed in a court of law. Okay, so enclosures and best practices, right? Um, so whenever you are trying to file a response, you have a paragraph wise, response to each and every allegation, each and every aspect of whatever has been mentioned in a writ, in an averment, in a revision, in a whatever plea they have filed, right? While you are doing that, you also mention certain documents that this document is this regulation is this. So if you are mentioning, for example, that this regulation did this, you have to make sure that a copy of that regulation is appended to your response, because nobody is going to open a computer during the court of law and actually look into that particular document online to verify what you're trying to say over here, right? So you should always include the orders, permits, office notes, Supreme Court, High Court decisions that you are referring to. You must have a copy of that. Government orders that you are referring to in your response, you must have a copy of that. So generally, the best practices is that ensure all documents are there. They're clearly labeled. They are clearly annexurized. They are attached to your pleadings or your response. Cross references are very important in your initial paragraph parawise pleadings or response. Uh, and then once you have that, make sure that you have a copy of that in a way which is organized for future references, because you don't want a situation to occur where, like, for example, a case is going on, and let's say after 2 years or 3 years, you are looking for some sort of an order that you had already filed and you don't have a copy of that. That's going to be very embarrassing for you. And sometimes, I mean, right now, nowadays, we have most of these things available online, so you can always search, Google it, and get the information. However, even though you have all that information, if you think that there can be a problem, if you don't want to have a hard copy, just scan every document when you are submitting it to the court, create a file on your computer and save it over there so that it is available for future reference. Very important aspect in terms of court cases, because there has to be an institutional memory, because if you get promoted or if you get transferred, someone who comes in your place in future may have a problem accessing those things. So note it down somewhere that these are the files in computer, these are the things which can be referred to in terms of institutional memory or in terms of whatever filings have been done. That's a best practice or use case scenario. Um, so as we are talking about handling cases filed against the government, in your cases against your institutions. Um, so when it is a non-writ case means when there is a problem with with land holdings or some sort of other problem, right? There can be a notice under Section 80 of Civil Procedure Code received by the concerned officer, and in case involves a department not under your official control, you should forward it to the head of the department. Now, in your case, what it means is that, for example, you are dealing with court cases and there is some sort of a litigation with regard to, let's say, uh, admissions, or let's say regarding exams, or maybe now what I've seen recently is that there have been issues of plagiarism where the professors have said that this student plagiarized, used AI, or did something, and then eventually the student ends up going to a court of law for a civil remedy, and then the court summons you. So you have to make sure that the department that is involved is taken into consideration. So you have to, forward to the either to the department or to an authority which manages or heads that particular department, right? What you need to do, or what the HOD needs to do is they need to have a detailed inquiry into the facts and the history of the case. Again, very important, pairwise comments and a comprehensive report. And then there has to be a decision within the organization that whether they want to meet the plaintiff outside the court to have a settlement and save money and time for both the institution and the plaintiff, as opposed to contesting the claim, ending up, fighting the case for a long period of time, paying the counsel, spending the money, deploying the resources, and it should always be in your consideration that when you're trying to file a complaint rather than trying to settle it down, you are not concerned in your organization because you are not paying it out of pocket. But eventually, remember that money is being spent, and trying to maintain economic consideration should always be there while you are trying to decide what should be done in such cases. So when we are trying to when there are judicial scrutiny of administrative actions and a public servant's role, so sometimes there may be a decision, maybe by your vice chancellor, maybe by your registrar, maybe someone who's very senior. They comes up with a policy, they come up with a policy, they come up with a decision, and the court suo moto, wants to examine it, or the court wants to examine whether natural justice was followed, whether actions were arbitrary, discriminatory, beyond the jurisdiction, if the writ petitions have been filed, and if fundamental rights are violated, as the writs always claim. So there can be a judicial scrutiny on administrative actions, right? What is the role of the public servant? So the public servant, they must exhibit independence, they must exhibit fairness, and they also must exhibit knowledge of legal procedures, right? Second, effective communication and adherence to court protocols are very, very important. So let me give you an example. As I had mentioned that I also, deal with criminal justice cases. I happened to be in a court of law earlier today, and there was someone testifying, and there was an objection to the manner in which he was reading from a document, and the counsel, she started telling the witness that they are not supposed to turn the document upside down, and the judge, the magistrate, actually was angry, and he actually said, Miss O'Brien, I hope you are not running the court. I am, so just keep quiet. So that was an embarrassing situation for the public counsel. So it's very important to maintain court protocols, and I've seen such things very often in my life. And actually, attending courts and handling these things are sometimes very exciting. But when you are, testifying or standing on the stands uh, as a witness, it can create a lot of anxieties. And I'm 100% sure if you're handling court cases, you will be in a witness box, every now and then, because there will be people filing cases against you. Anyone having experience standing in a witness box for a testimony or providing a witness? किसी को experience है?
नो सर।
चलिए, अच्छा है, नहीं है, बहुत एंजाइटी हो जाती है, बहुत दिक्कत होती है, क्रॉस एग्जामिनेशन में बहुत दिक्कत होती है। आपको भी नहीं है जिनसे हम लोग अब बात कर रहे थे?
ध्यान जी।
नहीं नहीं, अभी आई आई डोंट रिकॉल द नेम। इट वाज, आई थिंक, हाँ, अभी हम लोग बात कर रहे थे डॉक्टर समथिंग।
ध्यान जी।
ध्यान जी से, यस। अच्छा, है नहीं अभी वो? क्योंकि उन्होंने जरूर टेस्टिफाई किया होगा अगर वो कोर्ट केसेस बहुत दिन से डील कर रहे हैं। डॉक्टर ध्यान नहीं है, ओके cool. Anyways, but it is very interesting to actually be in that witness box. It's strange. मैं इंडिया में भी विटनेस बॉक्सेस में रहा हूँ. It's very different from how it happens in India and how it happens over here in California in United States. Things are very different, but वो जो एंजाइटी होता है, वो टेंशन सेम ही होता है.
सर जैसा मूवीज में रहता है वैसे ही होता है सर?
ना ना ना, मूवीज में तो ड्रामेटाइज करते हैं.
नहीं नहीं,
मूवीज में
अपन का हॉलीवुड मूवीज में होता है ना जैसा।
Sir, for cross examinations, one should be aware of all each and every fact of the case.
वेरी ट्रू. लाइक क्रॉस एग्जामिनेशन, देखिए, आप एक चीज समझिए, जब भी कोर्ट केस होता है तो कोर्ट केस के अंदर जब भी आप कोई चीज अगर देते हैं तो यू आर ट्राइंग टू प्रोवाइड इट एज एन एविडेंस, राइट?
Yes,
तो
sir.
जो या तो एविडेंस फॉर में होता है, फेवर में होता है, या एविडेंस अगेंस्ट में होता है. तो अगर
Yes, sir.
फॉर में हुआ तो जो अपोजिशन पार्टी है वो आपको क्रॉस एग्जामिन करके वो सिर्फ और सिर्फ उस एविडेंस को डिस्क्रेडिट करने की कोशिश करेगी. तो डिस्क्रेडिट करने के लिए दो चीजें डिस्क्रेडिट की जाती हैं. एक तो आपके नॉलेज को, कि आप कुछ नहीं जानते हो, आप बेवकूफ हो, आप जो एविडेंस दे रहे हो वो गलत है, right? The second is your intention. When you are providing that evidence, I want to discredit your intentions in providing that evidence. कि आपका कोई वेस्टेड इंटरेस्ट है इसके अंदर, और आपका वेस्टेड इंटरेस्ट अगर मैं प्रूव करता हूं, then it is not admissible in a court of law as an evidence.
Yes, sir.
हॉलीवुड मूवीज जो हैं वो ज्यादा अच्छा रिप्रेजेंटेशन करती हैं यहाँ के कोर्ट्स का. और यहाँ के कोर्ट्स जो हैं एक्चुअली, जजेस वगैरह वो बड़े बड़े पहनते हैं तो ठंड बहुत लगती है. बहुत जबरदस्त एसी चला के रखा होता है, एज अपोज टू इंडियन कोर्ट्स जहां पर शर्ट भी गीली हो जाती है पसीने की वजह से. बट इट्स इंटरेस्टिंग. इट्स इन लाइक जो एंजाइटी और जो टेंशन रहती है, वो हीट दोनों में लगभग वही रहती है.
सर एंजाइटी तब बनती है जबकि फैक्ट्स ट्रुथफुल ना हो. मतलब अगर कोई
देखिए
एविडेंस
आप,
दिया है उस पर आप श्योर नहीं है तो एंजाइटी उस टाइम में बनेगी, कहीं कोई क्वेरी उस पर ना बन जाए.
नहीं, आपने कोर्ट केस अटेंड किया है?
सर मैंने बहुत कोर्ट केसेस अटेंड किए सर.
अच्छा, इसका मतलब कि आपको क्रॉस एग्जामिन कभी ढंग से किया नहीं गया है. क्योंकि जैसा मैंने बताया है कि आप जो ट्रूथफुल चीजें दे रहे हैं ना, दैट इज नॉट इम्पॉर्टेंट, बिकॉज ट्रूथफुल मीन्स आप मान रहे हैं वो ट्रूथफुल है. जब भी क्रॉस एग्जामिनेशन होता है, इट इज ऑलवेज, यू आर ऑलवेज अ टारगेट ऑफ द क्रॉस एग्जामिनेशन काउंसिल टू डिस्क्रेडिट व्हाट यू आर सेइंग और डिस्क्रेडिट योर इंटेंशंस, राइट?
ये
आपके
सर.
इंटेंशंस को जब डिस्क्रेडिट करने के लिए क्वेश्चन किया जाता है ना, वो
जी सर.
बहुत गलत होते हैं, बहुत
जी
गलत
सर.
होते हैं. आई विल गिव एन एग्जांपल. मैं दिल्ली में साउथ जोन में असिस्टेंट कमिश्नर था. तो वहां पर एक टैक्सी स्टैंड था. तो टैक्सी स्टैंड जो था वो रिसेंटली उन लोगों ने क्या किया था कि वो गली में था, और गली के बाहर उन लोगों ने फुटपाथ पर एक वो डाल लिया था, क्या कहते हैं, शेड डाल लिया था. और वहां पर उन लोगों ने क्लेम किया था कि ये तो हमारा 20 साल पहले से है. सो हमने उसको सील कर दिया, उसको हटा दिया वहां से. एंड देन दे फाइल्ड इन अ कोर्ट ऑफ लॉ कि भाई हम तो 20 साल से कर रहे हैं, और जो वेंडर्स एंड हॉकर्स का एक प्रोटेक्शन का जो ऑर्डर आया था उसके वायलेशन में है. तो हम लोगों ने वहां पर एविडेंस दिया कि आज से कुछ दिन पहले, अलोंग विद अ न्यूज़पेपर फोटोग्राफ, ये सब नहीं था यहाँ पर. तो वो जो मेरे को जब क्रॉस वो कर रहा था, उसने कहा कि आपने तो इनको वहां से अपना बुलडोजर से हटा दिया, हटा के साफ करके आपने ये फोटो खींच ली. तो मैंने कहा ऐसा नहीं है. एंड देन ही स्टार्टेड टॉकिंग इन अ वे कि मैंने ये जानबूझ के ऐसा किया है, और मेरे को, आई वॉज नॉट एबल टू अंडरस्टैंड हाउ टू काउंटर दैट, बिकॉज ऑफ कोर्स दैट इज पॉसिबल, बिकॉज मेरे पास अथॉरिटी है उसको वहां से हटा करके फोटो खींच लेने की. मैं तो ट्रूथफुल था, लेकिन मैं कैसे उस बात को डिफेंड करूं, और मैं नहीं बोलूंगा। एंड एक्चुअली जज सॉ दिस एंड जज देन स्टॉप द काउंसिल द क्रॉस क्वेश्चनिंग, बोले कि नहीं नहीं, ये ऑलरेडी सबमिटेड है, आप इसको क्रॉस आर्ग्यू नहीं कर सकते।
जी
तो इट बेसिकली डिपेंड्स आप किस कोर्ट केस को हैंडल कर रहे हो, हाउ मच मीट इन द बोन इज फॉर द ऑपोजिशन पार्टी।
जी
और एक चीज और इम्पोर्टेंट है, सामने जो वकील है वो कितना स्मार्ट है, उस पर भी डिपेंड करता है।
जी
अगर वो
सर।
बहुत स्मार्ट है, बहुत आर्टिकुलेट है, तो दे विल गिव यू हार्ड टाइम, दे विल गिव यू हार्ड टाइम।
जी सर।
Anyways, that was in the right vein. But it is, आप did you appear in a court as per your official duties या something else?
सर इन पर्सनल कैपेसिटी सर।
पर्सनल कैपेसिटी उतना स्ट्रांग नहीं होता है।
जी
पर्सनल
जी।
कैपेसिटी वो अलग चीज होती है। आई एम टॉकिंग अबाउट व्हेन यू आर आर्ग्यूइंग इन योर ऑफिशियल कैपेसिटी,
नो
क्योंकि
सर,
आप जो चीजें
इट वाज
प्रोवाइड कर रहे हैं,
नॉट इन ऑफिशियल कैपेसिटी सर।
वो थोड़ा सा डिफरेंट हो जाता है, वो
जी
डिफरेंट हो जाता है। खैर, एनीवेज, इट्स ऑल गुड, लेट्स मूव फॉरवर्ड। तो हम लोग ओके जुडिशियल स्क्रूटनी की बात कर रहे थे। इफेक्टिव कम्युनिकेशन और अडेरेंस टू कोर्ट्स प्रोटोकॉल बहुत इंपॉर्टेंट है। प्रॉपर स्क्रूटनी जो है, इट इज एक्चुअली इम्पॉर्टेंट बिकॉज इट इंश्योर्स अकाउंटेबिलिटी एंड फेयरनेस इन गवर्नमेंट एक्शंस, बिकॉज दैट इंश्योर्स कि अब आई डोंट नो आप लोगों ने देखा है कि नहीं देखा है। कई बार तो ऐसे बहुत सारे चैनल्स भी है जहां पर कोर्ट जो है वो असिस्टेंट कमिश्नर्स को या डिस्ट्रिक्ट मजिस्ट्रेट्स को बुला करके लताड़ देते हैं बहुत बुरी तरह से। सो ट्रस्ट मी ऑन दैट, इट इज रियली, क्योंकि आप फील्ड में जब रहते हैं तो आपको लगता है कि हम तो बहुत खुदा हैं, हम कुछ भी कर सकते हैं। बट व्हेन अ केस इज फाइल्ड अगेंस्ट यू और आपने एक बार अटेंड कर लिया और आपको कोर्ट में अगर जज से एक बार लताड़ पड़ गई, तो उसके बाद आप नेक्स्ट टाइम कुछ भी करते वक्त 10 बार सोचोगे कि अगर कोर्ट में गया तो क्या होगा। सो प्रॉपर स्क्रूटनी जो है ये इंश्योर्स अकाउंटेबिलिटी एंड फेयरनेस इन गवर्नमेंट एक्शन। उसके बाद आप जबरदस्ती उल्टे सीधे काम नहीं करते हो, यू डोंट ट्राई टू शो योर अथॉरिटी। वेरी इंपॉर्टेंट। Okay, again, let's talk about the key best practices when it comes to litigation management in government or anywhere. आपका जो लीगल एक्सपर्ट है, उससे हमेशा लीगल और कॉम्प्लेक्स जो क्वेश्चंस है उसको डिस्कस करके रखिए as far as possible, unless if it is mandated by a court कि आपको एक particular language में बात करनी है, try to have the proceedings in English so that it is a universal language. Unless, as I said, it is mandated by a court कि नहीं हमें we will accept Tamil, right, or we will accept only Hindi, right, then it's a different matter. Otherwise, try to have everything in English, because English is the only language which connects the whole of India. और कोई ऐसा लैंग्वेज नहीं है जो पूरे कंट्री को कनेक्ट करता है in any proceedings. उसके बाद, as I said, maintain a detailed register. If you computer, you have a database of civil suits or like whatever court cases that you have and appeals involving the government. Use technology to create databases. Ensure prompt, objective, and accurate submissions of all documents. ये ज़रूरी है। और उसके बाद देर आर सर्टन टर्म्स जो यहाँ पर हम लोग रखे हुए हैं। लेट्स डिस्कस दीज टर्म्स। एडजुडिकेशन क्या होता है? Adjudication is basically the process under which a judge reaches a particular decision, right? So it's basically judgment, adjudication. But judgment जो है वो order होता है, adjudication is a process of reaching to that judgment, right? Affidavit, as we all know, it's a sworn statement. It can be filed by the petitioner, it can be filed by the responder, it can be filed by anyone. हम लोगों ने ऑलरेडी डिस्कस कर लिया क्या उसके पार्ट्स होते हैं। अपील वी ऑलरेडी डिस्कस्ड कि कोई डिसीजन हो जाता है, उसको क्वैश करने के लिए, उसको चेंज करने के लिए, उसको ऑल्टर करने के लिए, उसको रिस्ट्रेन करने के लिए अपील फाइल की जाती है। Attestation is basically someone attributing genuinity to your document, और चाहे वो कमिश्नर हो चाहे कोई गेस्टेड ऑफिसर हो। बेंच जो है वो बड़ा गलत शब्द है। पता नहीं, हो सकता है एक जमाने में जजेस बेंच पे बैठते होंगे। अभी बेंच का मतलब होता है कि हाउ मेनी जजेस आर इन्वॉल्व इन अ पर्टिकुलर केस। सिंगल बेंच मींस एक जज, डबल बेंच मीन्स टू जज। फुल बेंच जो होता है वो डिपेंड करता है फ्रॉम कोर्ट टू कोर्ट। फुल बेंच कई बार 7 जजेस का भी होता है, सुप्रीम कोर्ट में शायद ये 5 जजेस का होता है। सर अगेन
सर
उस
5 मेंबर्स सुप्रीम कोर्ट का बोल रहे थे ना सर, बेंच वो 5 जनरली 5 दिखता है ना सर।
हाँ, 5 सुप्रीम कोर्ट 5 का होता है। Contempt is when you violate the protocol, the quorum, or the directions of a court, right? अगर आपने कोर्ट का प्रोटोकॉल को वायलेट किया, दैट्स अ कंटेम्प्ट ऑफ कोर्ट। आपने कोर्ट के डिसीजंस को वायलेट किया, दैट्स अ कंटेम्प्ट ऑफ कोर्ट। आपने कोर्ट के कोरम डिसिप्लिन को वायलेट किया, दैट्स अ कंटेम्प्ट ऑफ कोर्ट। कैविएट बेसिकली एक रीजन होता है या क्या कहते हैं उसको, subject to this condition, that's a caveat। डिक्री जो होता है ये एक तरह का डायरेक्शन होता है ऑफ अ कोर्ट, इट्स नॉट अ जजमेंट, इट्स अ डायरेक्शन बेसिकली। एक्स पार्टे वी ऑल नो व्हेन द डिफेंडेंट इज नॉट प्रेजेंट, एक्स पार्टे हो जाता है। पिक्यूनरी जुरिडिक्शन मतलब प्राइमरी जुरिडिक्शन, मतलब अगर किसी कोर्ट के ऊपर जो जो प्राइमरी जुरिस्डिक्शन कहीं पर एस्टैब्लिश की जाती है, दैट इज पिक्यूनरी जुरिस्डिक्शन। प्लीडर होता है जो प्लीड करता है वेदर गिल्टी और नॉट गिल्टी, इसको डिफेंडेंट भी बोल सकते हैं। प्रोसीडिंग्स आर द पार्ट्स ऑफ द कोर्ट, जहां पर जो 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 प्रोसेस चलता है उसको प्रोसीडिंग्स बोलते हैं। प्रोसिक्यूटर इज द पर्सन हु प्रोसिक्यूट्स, बेसिकली इट इज इन क्रिमिनल केसेस। Stay order is an order of a court which stops the implementation of a certain judgment, right? Sub judice means the matter is under consideration or discussion or uh, under adjudication in a court of law. सुओ मोटो का मतलब होता है अपने आप। सुओ मोटो केसेस के अंदर किसी प्लीड की, किसी कंप्लेंट की जरूरत नहीं होती है, कोर्ट अपने आप वो कॉग्निजेंस ले लेता है, जिसको हिंदी में संज्ञान भी बोलते हैं। वकालतनामा एक बहुत इंपॉर्टेंट चीज है। इट्स बेसिकली एन अग्रीमेंट बिटवीन द पर्सन और द क्लाइंट एंड द लॉयर। वकालतनामा एक्चुअली it authorizes a counsel or a lawyer to represent its client in a court of law। बिना वकालतनामा के आप किसी को कोर्ट में रिप्रेजेंट नहीं कर सकते। And then what is a writ? Writ petition, we've already discussed different types of writs, and any petition filed claiming that writ is a writ petition, right? Section 80 of civil proceedings जो है, it requires a notice to be served on the government or public officer, specifies details such as name, description, residence, and cause of action in the notice. It provides that even if there is an error in the notice, the suit shall not be dismissed if substantial details are provided. So अगर आप काउंटर करते हैं किसी भी पिटिशन को और बोलते हैं कि इसका जो नोटिस है इसमें ये गलती है, इसलिए इस पिटिशन को वर्ड कर दिया जाए, तो उसको इग्नोर किस कंडीशन में किया जाएगा? जब उस एरर के अलावा सब्सटैंशियल डिटेल्स प्रोवाइड किए गए हों, राइट? सो फार सो गुड। सो अप until now, are there any questions, concerns, comments from the participants? Now, because of the fact that we are going to move on to next section, in which I'll be discussing basically how to handle CAT cases, most of the process is going to be similar as to how we have handled everything else. I'm just going to do it over here, and what you're supposed to do is consider it as handling cases in maybe a district court or a high court, depending upon what the level of petitions are, whether it's a civil matter, a criminal matter, or for that matter, a writ petition, right? So just ignore that it is CAT because most of the times process and procedures will be the same. Let's talk about this. अच्छा, ये चीज़ एक इम्पॉर्टेंट है जो कि आपको समझना है। बेशक से यू आर नॉट गोइंग टू गेट केसेस फ्रॉम कैट, बट एडमिनिस्ट्रेटिव ट्राइब्यूनल्स जो हैं, they are not bound by the CRPC and Evidence Act and all those things, which have now been renamed as Bharatiya Nyaya Samhita, Bharatiya Nagarik Suraksha Samhita, and Bharatiya Sakshya Adhiniyam. So this is a very interesting aspect of CAT, right? That CAT is not bound by these proceedings. Now, because of the fact that most of the cases for you in terms of administrative matters will be dealt in High Court, these provisions can come into play while you're having a discussion over there. Uh, so we'll just, go over these things quickly. In terms of, so imagine that what we're doing here is also relevant to the high courts, because this is a little bit more detailed than what we covered during the writ petition and everything. But requirements will be the same for both writ petition high courts uh, and other civil courts, civil matters or criminal matters if they come across to you, right? तो सबसे इम्पोर्टेंट होता है that जो jurisdiction है वो ascertain होनी चाहिए. If someone is filing a writ petition in a high court, or if there is a certain matter which is filed as a civil suit in a district court, uh, it is very important for you to ascertain whether it has been filed in the right place or not, right? Generally जो applicant होता है वो अपने jurisdiction में file करता है. You can always claim कि this jurisdiction should be transferred, which generally is not agreed upon unless there are valid reasons for the transfer, right? So जहां पर भी उसका करंट सर्विस है या जहां पर भी जो प्लेंटिफ है अगर वो नॉन सर्विस मेंबर है, जहां पर भी उसका प्रेजेंस है, दे कैन फाइल इन दैट लोकेशन. However, in matters of civil case, you can always plead transfer of the case to the jurisdiction of your institution, not in service matters, right? Service matters में जहां पर employee है वो उसका jurisdiction है, but civil matters में you can always get it transferred to your jurisdiction. So इसके अंदर mentioned ही है, it should be applicant's current posting or place where the cause of action arises. जैसे मैंने कहा civil matter है तो cause of action हमेशा आपके institution में arise करेगा, तो you have to get it transferred over there. And if the person is retired or dismissed, the place of residence of that person will be the place where you actually where those petitions are actually filed. So pre-filing requirements are that in case of universities, as we've discussed, that writ petitions are filed. So it should be ensured before anyone files a writ petition in High Court in terms of service matters, a final order has been issued by the competent authority in terms of disciplinary proceedings. When it says order must be final and issued by the competent authority, it also means that once the disciplinary proceedings has been culminated, an order has been filed. After that, a reasonable time has been provided to the officer to make an appeal, and after an appeal and consideration of the appeal, it has been decided that the appeal is rejected and the final order after that has been passed. So if the appeal has not been considered and the person goes directly to a court seeking judicial remedy, it can always be said that all the options available to the plaintiff has not been addressed up till now, right? Uh, any appeal or representation must have been rejected, as I said, or remain unanswered for at least 6 months. अगर मान लीजिए आपने उस ऑर्डर को के अगेंस्ट अपील फाइल करी है और उसको रिजेक्ट कर दिया गया है और नहीं रिजेक्ट किया गया है, उसका जवाब नहीं मिला 6 महीने तक, तब भी आप पिटिशन फाइल कर सकते हैं. Okay, so it just repeats the same thing that final decisions and that awaiting appeal results beyond 6 months are eligible for judicial remedies. Okay, so this take it with a pinch of salt. आप थोड़ा सा इसको verify करना होगा whether these limitations actually are available for writ petitions or not, because in terms of a redressal for your service matters, standard filing period should be within 1 year from the date of the final order, or 6 months after the lapse time of an appeal, right? It should not go beyond that if there was no order passed on your appeal. Adhering to the limitation periods is very important to prevent cases from being dismissed on technical grounds. So if someone goes to a court of law without actually adhering to these kind of things, the case will be dismissed straight away. Timely action is crucial to preserve the right to challenge an order, because if an order is there, and if even you want to challenge a high court order and go to Supreme Court, it's very important that you actually adhere to the timeline. Uh, so the timeline, I'm not sure how much for writ petitions it is permitted, but if it is a timeline which needs to be taken care of, uh, the courts may have a discretion in deserving cases to relax time limits in deserving cases. Okay, this is not important. Decision makers. We can talk about relevant things. So, like, I mean, high courts, they are located in several places. No need to discuss where they are. Each state has its own high court. Bigger states may have two benches of the same high court. Uh, and there are like jurisdictional boundaries as state boundaries for each high court. Cases are generally decided either by a single functionary, a single bench, or two members, a division bench. Uh, a CAT definitely has an administrative and a judicial member, but in High Court, both of them will be a judicial member. There is no administrative member permissible in those cases. So these are the cases which are dealt with in CAT, but because of the fact that in High Court they are writ petitions and basically they are fundamental rights, these divisions are not applicable to High Court. But if you have CAT cases or if you deal with CAT cases, generally, if there are cases which are dealing with date of birth, if there are adverse entries on your ACR which you want to find a remedy to, for compassionate appointments, allowances, LTC, transfer pension, GPF, etc., you go to a single bench. And when it comes to seniority, promotion, termination, disciplinary proceedings, resolution of conflicts, etc., division bench functions. And if there are like bigger conflicts in terms of interpretation of laws and regulations, a full bench is required. Okay, so filing process is actually the same in High Court as well. You need to submit the application format. Writ petitions, I don't think there is any fee attached to that. However, there will definitely be an initial scrutiny at the registry. Documents are reviewed for deficiencies, and filing number is always allotted when you are filing a writ, even in a high court. Uh, and it is very important that once that scrutiny level has passed, then only it is decided whether to admit that writ or not. Generally, the writs are not denied unless there is a reason to believe that there is a falsification of information in the petition. So again, apart from writ petition, there can always be, original applications, not regarding directly to writ petitions, but other things. There can be transfer applications where you actually transfer a petition from one court to another. There can be a review petition for reviewing an already uh, adjudicated matter. There can be a contempt petition where the court has already passed an order and that order has not been followed. So a contempt petition can be filed. And then uh, petition for transfer, you can file a petition that I want to get this case transferred to this particular region or area or to court because of certain reasons. And then there can be miscellaneous applications depending upon the requirements of the case. So who can file an application? Now this act is attributable to basically Administrative Tribunal Act. However, a person who is filing any case in a lower court or a sessions court has to file in the related acts. If a writ petition is being filed, it is under constitutional act that the writ can be filed. And what is important is that when you are filing any application, the application uh, s- should have like the laws, regulations, or the provisions should come within the jurisdiction of that particular court uh, for taking a decision in the matter. So what happens is that once this is received in a court, then okay, apart from having these things received personally, the notices can be received by post. It can be received official by officials, or dusty. Dusty basically means by hand. Uh, and when it is received, you have to acknowledge it with date and time of the receipt. It is very important for you to mention the date and time of the receipt, because that actually will entail, if there is a delay in delivery, then you can actually mention that my response is not delayed. The notice was received at a time which was really very late. So when you look at the notices, it's kind of the same even for High Court. So the notice that is received is notice of for admission. So if a petition is admitted, there will be a notice of admission. Respondents will be asked to show uh, cause against admittance of an application, irrespective of the fact whether it's uh, a writ or something else, right? And it is important for the court to understand whether the writ is maintainable or not. If it is not maintainable, then the person who's responsible for administration of that particular court case in an institution should always challenge the admissibility right at the onset. And if the admissibility is challenged and it is accepted, the writ petition generally doesn't get accepted. Now you file that, okay, it should not be admitted. However, it is admitted. You will again receive a notice that, okay, we received your response, but it has been admitted. Now what, right? Then you respond to all the, paragraph-wise information on that. And then what happens is, like, for example, if a writ or any other notice of admission is received and there are more than one departments involved in this, then it's your responsibility to make sure that the notices are distributed to all the concerned persons within your organization. So make sure that if it is involving more than one people, then you are supposed to make sure that every single person has been received. If you are the point of contact who receives the initial notice. Generally, what happens is there are more than one respondents. The notices will be sent to each and every respondent, but if it is addressed to your head of department, however, the matter pertains to more than one department, then it's your responsibility to make sure that all the departments are given a copy of that notice, and someone has to coordinate and someone has to decide who will be the person responsible to coordinate this kind of information, right? As I gave an example in terms of a student actually plagiarizing and then university taking a decision against the student and student going to a court of law, and then uh, they I mean a notice is received by the university. So it's very important for the university to make sure that admissions department of like whatever department the student was studying in, the professor who was involved, all of them are taken into confidence, and there is a coordination between these departments while you are trying to respond to that particular allegation of action or inaction which led to violation of some sort of liberty of that person, due to which the student went to a court of law to seek remedy. So as we've already discussed, what should be the departmental actions upon receiving? Uh, The first step is verify the complete package of applications and annexures. So when you receive a notice, there will be a pleading, there will be an annexure, there will be all the things which are being claimed by the petitioner. All that information will be there. So you are supposed to make sure that each and every enclosure is available. It should not happen that you get the complaint and after 15-20 days you write to the court or to the petitioner that this information was not provided. I mean, there should be a legitimate time between when you are receiving that document and when you are actually you are responding to that information and asking for additional information. So once you've identified and ensured that all the documents and annexures are available, then you identify the main respondent, right? The main respondent will be generally the respondent number one, right? If there are more respondents, there will be respondent one, respondent two, respondent three, respondent four, but main respondent is respondent number one. And then you identify within your institution what is the department that is going to manage that petition, and then ensure that the documents are supplied to that department so that they can challenge either the order or acceptance of notice or whatever. They're supposed to take action against that. Apart from that, make sure that there is a coordinate effort among departments if multiple respondents are involved. Uh, so a prompt and thorough internal review is so very important in organizations which have specified legal branches. It's very easy for them to actually have this kind of information disseminated to different departments and to coordinate with different departments. However, in smaller institutions, sometimes it will happen that you may not have that kind of a independent office and it directly comes to your office. So it's very important to make sure that everything is arranged, everything is managed at a single place so that it is coordinated, well coordinated, and uh, the petitioner doesn't get an advantage in the court because of the fact that you are not able to coordinate a concerted effort and reply to the petition in time. Right? Any questions? So what happens is, what is the responsibility of the head of the department? They will serve notice to the private respondents if they are private respondents, uh, and then file an affidavit confirming either the compliance of the notice, or if it is a case, then responding by submitting an affidavit, right? Apart from that, the HOD should determine a defense strategy, how they're supposed to defend the case, right? Check correspondence information, engage a government counsel if you're working for the government, or a counsel if you're working in an other organization, or you can have an authorized departmental officer who can coordinate all these things on behalf of the organization, right? So it's time for another break. Let's take a 15-minute break and we'll be back after 15 minutes. And perhaps because of the fact that we are not taking up CAT in detail, maybe we will, end a little bit early. And we'll have some discussions in the end if you have questions. And then we'll go on from there. Okay?
जी सर.
These are very important because this is actually going to tell you that what are the things that you need to take care of in terms of you want to make sure that the petition or whatever, it's not accepted. So the first thing you need to look at this, if there is a statutory period before which the applicant was supposed to file it, look at the limitation, right? Then you look at misjoinder or not joinder. It means that all the relevant parties have not been addressed, right? Misjoinder means someone is missing or someone has been attributed wrongly. So that's always wrongly attributed and made a respondent. That can always be a reason for uh, ground for rejection of the for the petition or for your objections. Non-exhaustion of remedies, again very important. You can always say that the departmental remedies which were available, it has not been pursued. Jurisdictional issues, again, that this doesn't fall under the jurisdiction of the court, or it doesn't fall under the geographical jurisdiction of the court. Then plural remedies is that if someone is trying to seek relief, which is more than one, and the relief is not related to each other, you can always say is that plural remedies are being sought in one petition, so that's not acceptable. The petitioner should file two separate petitions for that. Res judicata is means that it has already been decided by a court. In this case, we are mentioning CAT, but you can always use it that the court has already decided or another authority has already decided about this. So there is no need for the court to take this again. Estoppel is when applicants' previous actions or representations prevent the current claim, right? So if they've already made certain actions or representations and after that they make certain new claims, you can always say that their own claims conflict each other. So this cannot be accepted. Then this is called suggestio falsi. Suggestio falsi means that the facts have not been provided, it has been suppressed. So it's very important to have these things in your mind when you're trying to respond, because these are the most important things which generally will result in non-acceptance of the application, or if it is accepted, in denial of the petition, right? So generally, these preliminary objections are tactical tools to challenge the admissibility of an application on technical grounds. Remember, technical grounds are the most important grounds for challenging any person's petition anywhere, right? Very good tool. And then a strong preliminary objection can lead to early dismissal, which will save time and resources. So, long ago, while I was undergoing my training and we were being taught how to handle court cases, this the person who was teaching us, he told us that this is the backbone of any dismissal petition, like any claim that you can make in terms of dismissing someone's petition. Okay, so once it is already there, so how do you prepare a reply? Step one, verification and fact checking. We have already mentioned that. Scrutinize the facts as represented in original application. In this case, when we're talking of a high court, it's going to be a writ petition. Cross-check the details with internal records. Then you collect all the documents, gather the documents supporting your position, that's your department's position. Identify any similar cases or precedents that we've already discussed that support your argument. Referencing similar cases can actually reinforce the response and streamline the defense process and it's also going to save time in terms of your arguments, counter arguments in a court of law. Now, what you do is, how do you reply? There should be an introductory section, right? Name and designation of the officer filing the reply, statement of authority and confirmation of the original application, in this case, writ petition, has been read and understood. Then it has a brief background of the case, right? That's the next section. You provide chronological presentation of relevant facts from the department's perspective. Then specific response, you accept or deny the averments made in the OA. In this case, it's going to be the prayer in the writ petition with clear para-wise replies. Then you should have a section on preliminary objections. Clearly state the objections regarding limitations, jurisdiction, etc., which we've already discussed. Clearly state any objections that you have. Do not falsify anything. If you believe there is a clear-cut objection, place it. If you believe it's not, don't do it. And then your concluding prayer, which means a formal request for dismissal of the writ petition with costs, followed by a verification statement. So this is actually a structure of how you respond. The reply must be complete, self-contained document, which is addressing every single point in the writ petition or the original application if you're handling CAT cases. The response should be clear, precise, logical. Every allegation must be countered either with an acceptance, which is an admission, or denial, which is a rebuttal, or an explanation supported by references with annexures if it is needed. Now, formatting and legal requirements, generally this is generally the same. However, the only difference being that in high courts, probably it's legal format, right? Uh, Margins are like 5 cm, 2 point. It's not very important. You can always your legal counsel is always going to tell you how to have the formatting. If there are some vernacular languages, you should have authenticated translation with a legal practitioner certificate. The annexures should be marked sequentially depending upon high court or CAT or like lower court. You should have exhibit 1, exhibit 2, or R1, R2, howsoever you want, and you should always take advice of your legal counsel to actually tell you how to format your responses. You should follow strict formatting guidelines, which is very important. Uh, if you don't do it, it may lead to rejections or delays. Indexing and presentation to it's also very important to show that you actually are intent upon solving the problems. And apart from that, while things are being discussed in the court, it is always easy to reference the information that is available, right? And ensure that all supporting documents are there. Uh, so when you're finalizing the reply, you should avoid repetition. Keep your language very clear, crisp. Full statutory provisions and clear prayers should be mentioned. Get the draft approval by the government council. There should be a vetting by the legal advisor. If you're in the government, it has to be undertaken through Ministry of Law and Justice. And then the authorized signatory has to sign it. Make sure that the sign is there before you actually submit it. And then once you file the reply, you should obtain an acknowledgement of your reply. After filing the reply, the applicant counsel must submit a rejoinder. The case is then listed for hearing or scheduled for an effective hearing. During the hearing, both parties present their arguments orally. Departmental officials should be present to liaise with the government counsel and clarify any doubts. So, practice is generally you should be there. The bench reviews the written submissions before delivering a decision. So, attending the hearing in person will ensure that your counsel doesn't have to come back to your office to get any documents if it is required, which is going to uh, stop any further delays in finalizing the case. So hearing generally is a case where both factual and legal arguments are tested by the court, and decision is then rendered based on all the submissions made by the plaintiff and the defendant, or in this case, by the petitioner and the respondent. Okay, so what should you do if the order is against the government? Immediate steps: obtain a certified copy of the order, right? Analyze the directions and assess the legal grounds of the order. In this slide, I'm saying CAT, but it can be High Court because the compliance is exactly the same, whether it's CAT or it's High Court. Then you need to consult with whatever the ministry or department or the legal counsel that you've hired. Advice: what should we do, right? Decide whether to implement the order or challenge it further. So if you want to discuss with the legal counsel and see that your arguments against the case were very strong, due to some reason it was against the government, and you want to challenge it, there should be uh, absolutely no doubt in the mind of the council or the department that after challenging, uh, you can actually, defend your decision of challenging it. If you believe that challenging it is not going to bring any new information and you may lose it, it's always better to implement the order in the name of efficiency, in the name of saving money, in the name of saving time and resources. Uh, uh, if you want to challenge, you can file a review application uh, or again a writ petition in a high court. Prepare a necessary documentation, reply, legal opinions, and all those things. You should always have that. Generally, an adverse decision requires immediate attention so that you can stop potential damage. A detailed analysis of the order is necessary because if you don't analyze the ramifications, what has happened, it's very difficult for you to ascertain whether, if it goes into appeal, whether you'll be able to defend your appeal or not. If you want to file a review petition or a writ petition, then you need to, support all the documents and ensure that whatever you could not support this time, it has additional information or support for your appeal. Otherwise, it will end up having the same fate. Okay, so review application grounds procedure. This for CAT, it is Administrative Tribunal Act. It is different for the high courts, but it is comparable, right? The review application generally it's filed when discovery of new or additional material evidence which was not available initially at the time of original decision, that's where we actually file a review petition. Or if you see that there is an error in the face of the judgment, the judge did not take into cognizance certain information, and because of which there seems to be an error which has occurred, you can file a review petition, or any other analogous reason where due diligence could not produce the necessary evidence required for the case. You can file a review petition along with those additional uh, evidences. So the procedure is a review petition is filed within 30 days of receiving the order. It may be different in terms of a writ petition from a high court. It is filed before the same bench that passed the original order unless it has been reassigned. Filing a review does not affect the right to appeal later. So if you're filing a review, it doesn't mean that you cannot file an appeal to this order later on, right? The review application is remedy for addressing clear errors. Strict timeline is important. Review is a limited remedy and does not preclude further appeals. Writ petitions and special leave petitions. So again, now we come to higher courts. So writ petition, it is filed in a division bench of the High Court under Article 226 of the Constitution. It is utilized when the government order or the order of your institution is challenged on grounds of constitutional violations or gross procedural lapses. And special leave petition is filed in the Supreme Court under Article 136. It is applicable only when a substantial question of law or an issue of great public importance is involved, right? Very important. It has to be of great public importance, and it should satisfy Article 136. It requires prior consultation with additional Solicitor General. So generally, special leave petition, I don't believe it will be admissible to autonomous organizations and universities. But I cannot say for sure that universities will not get an occasion or a chance to file this kind of a petition. I cannot vouch to that. So if a case is not satisfactorily solved, you can always approach higher judiciary. Um, a difference between a writ petition and special leave petition is that writ petition is specific in the High Court and special leave petition is broader for substantial matters in the Supreme Court. Always take legal counsel's advice before moving for higher level of remedies, as has been mentioned, because if at a lower stage, uh, the submission of your institution has been denied, there's all probability that an appeal will also be declined invariably. So you have to be very careful when you're filing appeals. Okay, contempt petitions, right? So if there is a civil contempt petition, what it means is that when a party fails to comply with a court's order. Criminal contempt petition is when this is not CRCP PC, this is now whatever Bharatiya Adhiniyam something. In cases of willful disobedience of court orders is a criminal contempt, often when directed against high-ranking officials. If high-ranking officials are directed to do something and willfully they disobey this, then it leads to criminal contempt petition. What are the preventive measures? Always file miscellaneous application for extension if more time is needed. Ensure strict adherence to the stipulated time frames. The time frames should be adhered to avoid contempt proceedings, right? Uh, Next is payment to government council. So this is something which is followed as a guideline. There can be separate requirements for your institutions and organizations, right? For a government council or for that matter any council, the payment components generally comprise of drafting and filing of replies. When you are actually defending the case during hearings, counsels are supposed to be paid. And apart from that, there may be out-of-pocket expenses for each effective hearing beyond 3 days. So if someone is coming to a particular place from a distant place, traveling, lodging, air travel, and all those things, so those are additional payments that are included for the councils. So for the purpose of scrutiny, it is very important that all the invoices, all the bills submitted must be reviewed according to the guidelines. In this case, for government, it's Ministry of Law. For you, it can be either your own legal department or you can actually follow Ministry of Law's guidelines. And you can reference specific OMs and notifications from the website of Ministry of Law to understand or to cite how you are going to scrutinize the invoices and the payments and everything else to the council. Ensure all expenses are justified and documented. So it doesn't mean that someone who's just living like 50 miles or 100 miles, they are actually coming by air instead of by road. I mean, this is unless it's like a time constraint thing, it may not actually be justified. And if it is something that you think is justified, whether or not justified, you have to document each and every expense for the purpose of accounting. In case there are discrepancies, uh, there are Ministry of Law guidelines or your own department's guidelines, accounting guidelines, which you can always refer to make sure that uh, all accounting is appropriately maintained. Government council's remuneration is regulated by strict guidelines, right? Always have and like make sure that there is transparency and accountability. Every expenditure must be scrutinized, documented. These guidelines protect government's financial interests or your institution's financial interests and your integrity in terms of the litigation process. So it is very important for you to understand and appreciate these guidelines. So basically, what we learned here is that we understand how strictly to adhere to jurisdictional and limitation requirements. We've learned how to prepare comprehensive, well-formatted, and self-contained replies, how to maintain complete and detailed records throughout the litigation process. We've also understood how to coordinate closely with legal counsel and department officials to understand and make sure the legal management, litigation management process of your organization is up to date and it's good and there are no delays, there are no harm financially or otherwise to your organization. You have to act promptly at every stage from receiving notice to post-order actions. Um, the most important is in litigation management is that your institution's interests, financial or otherwise, should be maintained and protected. So you must come up with efficient resolution of disputes. You should minimize litigation risk and costs, as I said. You should always try to uphold fairness and transparency in the government operations. So always remember, don't just go for an appeal because of the fact that you think embarrassed by the court's order and you think that someone, defeated you in a court of law. Don't take it as a defeat and don't get embarrassed. You should always remember that you have a responsibility, you have authority, and you should always have due diligence while implementing your authority, right? So with that, I would like to close this lecture. So do you have any questions, concerns, comments with regard to this?
Sir, I have two query, maybe related to suo motu, sir.
Uh-huh.
Can the authority exercise suo motu powers in certain cases within an organization?
So suo motu basically is for the courts.
So in the organization, the authority can't use it then.
So yeah, of course. Like I mean, there is no restriction in the government, right? In organization to take any decision on any matter. For that matter, most of the policy decisions or decisions in an organization they are suo motu. Like there is no proper channel in any organization for any policy drafting, policy implementation. So maybe the leadership decides to do something and they do it, and sometimes there are directions from the top. So suo motu is a concept which has been introduced in the legal system because prior to that, the court could not take up any issue unless and until there is an interested party which is seeking some sort of a redressal, right? So the concept of suo motu said that even if there is no aggrieved person, even if there is no person who's been impacted directly, we can on our own take cognizance of certain things that are happening in a society. And that is just a judicial process. So when it comes to an organization, there is no restriction on any sort of a policy, any sort of a decision. So if there is, I mean, no organization says that we are not going to implement any policy with regard to, let's say, leave, or let's say, raising the salary of someone, unless someone petitions for it. It's not a requirement in any organization. So the concept of suo motu doesn't arise in a non-judicial environment.
Okay, sir. Thank you. And second query, sir,
Hmm.
whether the employee is obligated to raise the grievances within the organization first before seeking judicial intervention, and if in the case directly approach to the court, will that amount to a misconduct or breach of the service rule warranting disciplinary action?
If someone actually reaches out to the court without I mean, exhausting all the departmental resources available, this is nowhere in the contract rules or any other rules it's mentioned that they can't do so, right? The thing is that if anyone does that, you raise this objection that they haven't even started in the any process in the administrative remedies which are available, and that petition will be immediately dropped in a court of law. You cannot initiate disciplinary proceedings just based on the fact that someone went to a court challenging certain decisions which have been happened in the court. The only thing that you can do is you can respond to that petition in the court stating that this is too early to go to a court, so it should be dropped, and court generally will drop and direct the person to go and exhaust all the administrative remedies prior to coming to the court.
Okay, thank you, sir.
But no disciplinary proceeding.
Okay, sir.
Cool. तो ये हमारी लास्ट क्लास है। जाने से पहले एक एक बार आप लोग शक्ल दिखा दीजिए, तो कि फिर अगली बार कभी मिलें इंडिया में तो कम से कम हाय हेलो हो सके। Cool. Great. Nice to see all of you. So I hope I was able to make certain things clear as far as how litigation management is done, and how disciplinary proceedings and all those things are done. Uh, so अभी तक जो कुछ भी मैंने बताया पढ़ाया, कोई कंसर्न, कोई कमेंट, कोई आपको ऐसा लगा हो कि नहीं समझ में आ रहा है, और any experience that you want to share, we can discuss it, or otherwise we can all leave.
Namaskar, sir.
Mhm.
Sir, can we get your email ID and contact details, sir?
Yeah, for sure. Jhaji के पास है. You can always get it from him.
Okay, sir.
Yeah, for sure. Why not?
Okay, sir. I will take it from Jha, sir.
या नहीं तो मैं एक काम करता हूँ, अभी जो चैट है इसके अंदर ये मेरा जो नंबर है, यू कैन यूज इट फॉर व्हाट्सएप।
Okay, sir.
और ये मेरा ईमेल नंबर है, ईमेल है।
Yes, sir.
Cool. मिल गया
Thank you,
चैट
sir.
में? You're
Yes,
welcome.
sir. We have received.
Great. जहाजी हैं क्या आज?
आ रहे हैं सर, आ रहे हैं जाजी, आ रहे हैं।
हम्म
आ रहे हैं सर अभी।
तो इन ऑल प्रोबेबिलिटी मेरी तरफ से जो था वो तो खत्म हो गया, सो आई होप यू कैन टेक ओवर, राइट? So I'll just say goodbye to all of you, and maybe we'll meet again someday, somewhere. तब तक
Goodbye,
के लिए
sir.
Okay, sir. Thank you, sir. Thank you.
थैंक यू सर, थैंक यू सो मच सर।
Thank you, sir.
Thank
You're
you.
welcome. Bye.
Bye, sir. Thank you.
आप लोग रुक जाइएगा, अभी सर आ रहे हैं।